Hello everyone, very good afternoon. Yes. So dear students, welcome back. Yes, welcome to Yoddha series, Legal Aptitude, paper number 2. So आज का क्या प्लान है? What we are going to do today? आज हम लोग रिवाइज करने वाले हैं दो चैप्टर्स, लीगल एप्टीट्यूड के दो चैप्टर्स, ठीक है? एक का नाम है इंडियन कॉन्ट्रैक्ट एक्ट, राइट, एंड दूसरा है एलिमेंट्स ऑफ कंपनी लॉ. दैट इज अवर टुडेज प्लान. चैप्टर रिवाइज होने के बाद हम क्या करेंगे? चैप्टर के MCQs सॉल्व करेंगे, इंपॉर्टेंट MCQs, पहले एग्जाम में आए हुए MCQs, राइट? सो दैट इज द वे वी आर गोइंग टू गो टुडे. सो MCQs एंड रिवीजन बोथ. चलिए देन शुरू करें. सो फ्रेंड्स, वी आर स्टार्टिंग फर्स्ट विद इंडियन कॉन्ट्रैक्ट एक्ट. यस, 1872. यहाँ से शुरू करते हैं चैप्टर को. बहुत ही इंटरेस्टिंग चैप्टर है, बहुत ही इम्पोर्टेंट चैप्टर भी है, राइट? सो यस, चलो. यस, चलो, हियर वी गो. इंडियन कॉन्ट्रैक्ट एक्ट 1872. अभी बच्चा लोग, आपको पता है इंडियन कॉन्ट्रैक्ट एक्ट 1872 क्या कहता है? इंडियन कॉन्ट्रैक्ट एक्ट 1872, सबसे पहली बात, इसकी जो इंपॉर्टेंट डेट्स है वो क्या है? आपको पता है ये जो एक्ट है इंडियन कॉन्ट्रैक्ट एक्ट, वो कब पास हुआ था? 25th of April 1872, ठीक है? सो तभी ये पास हुआ था और ये इफेक्टिव कब से हो गया था? 1 सितंबर 1872 से ये इफेक्टिव हो गया था, ठीक है? ये एक्ट एप्लीकेबल कहाँ पर है? दिस इज एप्लीकेबल टू होल ऑफ इंडिया, एंड पहले इट वाज एक्सेप्ट जम्मू कश्मीर, लेकिन आपको पता है उसके बाद क्या हुआ? उसके बाद ये चेंज हो गया. सो नाउ इट इज एप्लीकेबल ऑन जम्मू कश्मीर ऑल्सो, ठीक है? पहले आपको पता है ना, कुछ कुछ एक्ट एप्लीकेबल थे होल ऑफ इंडिया इंक्लूडिंग जम्मू कश्मीर, कुछ कुछ एक्ट एप्लीकेबल थे होल ऑफ इंडिया एक्सक्लूडिंग जम्मू कश्मीर. तो तब ये एक्ट जो था वो एक्सक्लूडिंग जम्मू कश्मीर था, लेकिन बाद में जो आर्टिकल 370 हट गया, यू ऑल नो दैट. तो उसके बाद ऑल द एक्ट्स आर नाउ एप्लीकेबल टू होल ऑफ इंडिया इंक्लूडिंग जम्मू कश्मीर. चलिए शुरू करते हैं. सो बच्चा लोग, ये जो हमारा एक्ट है इंडियन कॉन्ट्रैक्ट एक्ट 1872, इसको हमने हमारे टेक्स्ट बुक में डिवाइड किया है कितने पार्ट्स में? 7 पार्ट्स में, ठीक है? तो इसके अंदर जो फर्स्ट पार्ट है दैट इज यूनिट नंबर 1, वो अभी अपन शुरू करने जा रहे हैं. तो सबसे पहले हमारा ये चैप्टर शुरू होता है डेफिनेशन ऑफ कॉन्ट्रैक्ट से. यस, आपको पता है बच्चा लोग, कॉन्ट्रैक्ट का डेफिनेशन जो है वो कहाँ दिया है? कॉन्ट्रैक्ट इज डिफाइंड इन, as you know, all the definitions are given in section number 2. So contract is defined in section 2 subsection H. So what is a contract? आप सबको पता है contract is an agreement which is enforceable by law. जो अग्रीमेंट क्या है? एनफोर्सेबल बाय लॉ है, मतलब जो अग्रीमेंट सपोर्टेड बाय लॉ है, उस अग्रीमेंट को हम क्या बोलते हैं? कॉन्ट्रैक्ट बोलते हैं, ठीक है? अब सवाल ये आता है कि भाई देखा आपने, कॉन्ट्रैक्ट मतलब क्या है? अग्रीमेंट which is enforceable by law. अब सवाल ये आता है कि what is an agreement? तो बच्चा लोग, आपको पता है अग्रीमेंट का मतलब क्या होता है? अग्रीमेंट मीन्स वेरी सिंपल, इट इज जस्ट ऑफर प्लस एक्सेप्टेंस. अग्रीमेंट का मीनिंग क्या है? ऑफर प्लस एक्सेप्टेंस. यस, यहाँ पे आपको वो दिख जाएगा, ऑफर प्लस एक्सेप्टेंस. अग्रीमेंट का मतलब होता है ऑफर प्लस एक्सेप्टेंस, ठीक है? इजी एवरीवन. चलो, जैसे मैंने आपको कुछ ऑफर किया, मेरा मोबाइल फ़ोन 10,000 में खरीदेगा क्या? ऑफर. आपने कहा हाँ 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 हाँ, क्यों नहीं, एक्सेप्टेंस. तो ऑफर प्लस एक्सेप्टेंस हमारे बीच में क्या बन गया? अग्रीमेंट बन गया, ठीक है? अभी आपको पता है अग्रीमेंट बन गया मतलब हम दोनों के बीच में क्या बन गया? प्रॉमिस बन गया, ठीक है? अग्रीमेंट इज ऑल्सो कॉल्ड एज प्रॉमिस. एंड आपको पता है एक बार अगर अग्रीमेंट बन जाता है दोनों पार्टीज के बीच में, फिर दोनों पार्टीज को क्या करना होता है? देखो, ऑफर प्लस एक्सेप्टेंस इज एन अग्रीमेंट, एंड एक बार अगर पार्टी के बीच में अग्रीमेंट बन जाता है, उसके बाद दोनों पार्टीज के ऊपर बर्डन आता है. कैसा बर्डन? अग्रीमेंट जो बना है उसको पूरा करने का बर्डन. बोथ पार्टीज हैव टू परफॉर्म देयर रिस्पेक्टिव ऑब्लिगेशन. यस, I hope you understood this. Both parties have to perform the respective obligation. So once there is formation of agreement between two parties, parties have to perform their obligation. Yes. What if any of the party fails to perform the obligation? If any party fails to perform the obligation, then what will happen? Can other party sue? Yes, other party will sue, other party will take legal action. So if other party can take action, law is helping the suffering party in this. That means this agreement is supported by law. So if agreement is supported by law, that agreement will be called as a contract. Okay, so that is the case. Now tell me friends, can I say all contracts are agreements? Obviously, the contract starts with agreement. A contract is an agreement which is enforceable by law, right? So contract is an agreement. Contract is an agreement which is enforceable by law. So yes, contract is an agreement. But can I say all agreements are contracts? No. All agreements are not contracts. Why? Because only those agreements are contracts which are enforceable by law. Only those agreements are contracts which are enforceable by law. Therefore, all agreements are not contracts. All agreements are not contracts. Easy, everybody? So this is the point. Yes. So we did two things. What is a contract? What is an agreement? Now, after that, we start the topic with offer. You know friends, just now I told you agreement means offer plus acceptance. Agreement means offer plus acceptance. Now the point is, what is an offer? What is an offer? So friends, offer is a very big topic. There are four things in offer, right? That is definition, features, types of offer, lapse of offer. Okay? So yes, offer is defined in section 2, subsection A. Remember this, MCQ point of view, very important. Section 2, subsection A. Okay? Yes. So friends, see, you don't just need to make an offer, you have to make a valid offer. Only offer is not enough, offer must be a valid offer. Now when can we say that our offer is valid? When can we say offer is valid? You can say offer is valid only and only when it satisfies all the requirements of features. Yes, you can see the features here. When all the features are getting satisfied, only then you can say offer is valid offer. Come on, let's go with the features. First point says that offer must create legal obligation. See, there can be so many examples, right? Let's say for example, if I told you, will you come for a candlelight dinner with me? I'm making an offer to you. Correct? It's an offer. You said yes, yes I will come. So offer plus acceptance, it is an agreement now, right? So we decided to go for a candlelight dinner today evening 7 p.m. But then what you did? You didn't appear there. You didn't came. You didn't appear at the given time and place. So tell me, are you breaking the agreement? Yes, you have broken the agreement. So tell me now, can I sue you? Can I take you to court? So answer is no. Why? Because the offer made by me is not creating legal obligation. Okay, offer must create legal obligation. That is the requirement of the first feature. For this, there is very famous case law, Belfer versus Belfer. You know what happened in this case? There were two parties, husband and wife. Yes or no? Husband and wife. Husband, wife, there was agreement between them. Do you remember? Yes, both got separated because of dispute. Husband promised to pay monthly expenses to wife. So husband promised to pay monthly expenses to wife, and then later on, did husband actually make the payment? No. Husband didn't pay. So tell me, can wife sue? So in this given case, answer was no, cannot sue. Why? Because it was a case of only separation and not divorce. They just got separated because of dispute, but they didn't divorce each other. So therefore, the offer made by husband to pay monthly expenses is not creating legal obligation on him to make such payment. Therefore, it is not a valid offer made by husband. So if offer is only not valid, so why there is acceptance? There is no agreement only. Right? And when there is no agreement, there is no point of talking about contract. So first conclusion is offer must create legal obligation. Second, offer must be certain. Offer must be certain means offer must be clear. Whenever you make an offer, offer has to be clear offer. Okay? Yes. Like for example, if I say you, I will sell this jacket to you. I offer this jacket to you in 2-3,000 rupees. So what is this 2-3,000? It should be either 2,000 or 3,000. You can't say 2-3,000 because in this case your offer is not a valid offer. Because offer has to be certain, right? Offer has to be clear. Okay. Next. Offer must be different from invitation to offer. Offer must be different from invitation to offer. Now what is this offer must be different from invitation to offer? You know friends, offer is different and invitation to offer is different. Yes. You know all advertisements are invitation to offer. What is invitation to offer? Invitation to offer is something which leads to offer. Something which leads to offer. Example, you know, price tag. Yes, display of goods with price tag. When you go in a shop, you see there are so many goods which are kept on display with price tag. So display of goods along with price tag is not an offer, it is invitation to offer. It is invitation to offer, right? Yes, so remember this thing. So that is invitation to offer. Then what do? We see that invitation to offer, we enter the shop and then we make an offer. We tell him, yes, will you sell me this for so and so price? Right? So what is this? Display of goods is invitation to offer. This is advertisement, right? So this is invitation to offer. Come on, distribution of prospectus. Prospectus distribution. Is this an offer? No. It is again invitation to offer. Yes, when you go to a restaurant, they give you a menu card. Come on. Are they offering you something? No. That is not an offer. That is invitation to offer. Right? So basically all types of advertisements are called as invitation to offer. An offer is different, invitation to offer is different, right? So yes, so you saw something, that is offer must create legal obligation, offer must be certain, that is offer must be clear, offer must be different from invitation to offer, right? Then we say offer must be communicated. Very well known case law here, that is Lalman Shukla versus Gauri Dutt. Offer must be communicated. What is this? So the conclusion of this point is, who can accept the offer? So friends, offer can be accepted only by a person who is aware about the offer. Offer can be accepted by a person who is aware about the offer. Yes, that means offer is communicated. I cannot accept the offer if I don't know the offer, right? So that is the point. Offer must be accepted only by a person who is aware about the offer. Okay, so this was concluded in this case, Lalman Shukla versus Gauri Dutt. Okay, come on, next is offer can be expressed or implied. What is expressed? Express means use of words. Yes or no? Use of words, oral, written, everyone, yes? So whenever you make an offer orally or in writing, it is called as express offer. Are you getting the point? Express means use of words, that is oral, written, whenever you use words, it is called as express offer. Okay, what is implied? Implied is opposite of express, that is, in this we say there are no use of words. It is just by the conduct of party. It is just by the act of party. That is called implied offer. So offer can be expressed also, offer can be implied also. Now express offer, as you know, use of words, right? Oral, written, anything. But what is implied offer? That is, as I told you, no use of words, no oral, not even in writing. It is just by the conduct of party. It is just by the act of party. Like for example, if we are waiting at the bus stop, bus comes and bus takes a halt at the bus stop. Now tell me, did you stop the bus? No, you were just waiting at the bus stop. But bus came and bus took a halt at the bus stop. You know, the bus comes and takes a halt at the bus stop. What is this action showing you? This action done by the bus service provider is the act done by the party. Yes, act done by the party. This act done by the party is nothing but an offer. Which type of offer? Implied offer. Come on, when he stops the bus at the bus stop, is he going to shout like, are you coming, anyone is coming? Nothing, right? It is just the conduct done by the party, act done by the party. There are no use of words, it is the act done by the party. So such type of act done by the bus service provider is called as what? Yes, that is called as implied offer. I hope this is clear to everybody. Yes. Next is, so offer can be express also, implied also. Next is offer can be conditional. Offer can be conditional. What is can be conditional? You know, whenever we make an offer, if I make an offer along with a condition, when I make an offer along with a condition, it is called conditional offer. Like for example, if I tell you that I will buy your house, I will buy your property if you paint the house and give it to me. So I will buy your property if you paint the house and give it to me. What is this? It is obviously an offer with a condition. See, I will buy your house if you paint it and give it to me. I will do this if you do this. So I am making an offer along with a condition. Such an offer is called as conditional offer. Therefore we say offer can be conditional. Okay, what if you wish to accept my offer? What if you want to accept my offer? Can you accept my offer without condition? Come on, what do you think? No. If you say yes, okay, I agree to your offer, but you need to accept my condition also. Because I made an offer, I will buy your house if you paint the house and give it to me. If you say that, yes, I agree to sell my house, but I won't paint it, I will not paint it, you can't do this. If you agree to sell it to me, you have to paint it. Because I have not made just an offer, I have made an offer along with a condition. So that is called conditional offer, okay? So I hope this is clear to everyone. Yes, everybody clear? Any doubt in this? Everyone listening? Okay. So what's next? Yes, offer must not contain a term non-compliance of which will lead to acceptance. See, whenever we make an offer, offer must not contain a term. Term means that terms and conditions term. That's stipulation, right? So, when we make an offer, offer must not contain a term non-compliance of which. Non-compliance means not following it will lead to acceptance. Like for example, if I say you, will you buy my bike? So I'm making an offer to you. Will you buy my bike? So I'm making an offer. You told okay, I'll let you know. I told no, it's nothing like that. So do one thing. You keep my bike with you, okay? And if you want it or you don't want it, reply me in 2 days. Whether you wish to accept my offer or you don't want to accept my offer, let me know in 2 days. Now see, I'm offering my bike to you. But along with this, I have told you that there is one term, there is one stipulation that you have to reply me in 2 days. You want to buy my bike or you don't want to accept my offer, you need to reply me in 2 days. So in my offer, there is a term that you have to reply in 2 days, okay? So now what you did? You didn't reply at all. You did not say yes, you did not say no. So when I offered you my bike, you have to comply with the term which I had told you at the time of making the offer. See, when I made an offer, I told you that you have to reply me in 2 days. Now what you did you reply? No. That means did you comply with that term which I told you at the time of offer? No. You have not complied with the term. Therefore it is non-compliance of term. So if you don't reply, will that lead to acceptance? If you don't accept the term, if you don't follow the term, will that lead to acceptance? Answer is no. Because automatic acceptance is not a valid acceptance. Yes, as per the features of acceptance, even acceptance must be communicated. We will revise that in acceptance topic. Okay? Yes. Clear everyone? Yes. Okay, next. Now after the features, you saw there are 7 features. Next is types of offer. Very simple, come on. There are different types of offer. The first type is called as general offer. What is general offer? Very simple. Offer which is open for all. Yes, it is an offer which is made to general public. Who can accept the offer? Any person who is aware about the offer can accept the offer. Like you can see the offers made by sellers, vendors, Amazon. All these offers are general offer, right? These offers are open for all? Yes, it is open for all. Such type of offer are called as general offer. Who can accept it? Any person who is aware about it can accept the offer. For this, there was a famous case law, Carlyle versus Carbolic Smoke Balls Company Limited. Okay. Yes. Okay. Yes, Yuraj, it means that you have to comply the term. Yes. As we spoke about conditional offer, so it is connected with that. Okay. Yes. Still, if you have doubt, you can ask me at the end of the session also. We will explain you again in detail. As you know, this is a revision class, so we are just going with the revision, right? Okay. Now let's go to the next one. Next is, after general offer, next is special offer, which is also known as specific offer. See, in general offer, I told you offer which is open for all, correct? Offer which is open for all. Who can accept the offer? Any person, right? But special offer is totally opposite of that. Special offer means it is an offer which is made to a specific person or a specific group of person. Yes, this is an offer which is made to a specific person or a specific group of person. Such an offer is called as special offer, or you can also call it as specific offer. Come on, tell me in this, who can accept the offer? Any person or any group of person to whom the offer was communicated can accept the offer. Come on, I repeat. See, this offer was made only to a specific person. So who can accept it? That particular person only can accept it. Obviously, who is aware about it? Okay, who can accept this offer? Only the specific group of people can accept it, no one else. Okay, next is cross offer. What is cross offer? Come on, very simple. Cross offer means these are two offers which are made at the same time for the same thing. Yes, the two offers which are made at the same time for the same thing. Like two people are making same type of offer at the same time to each other. Like for example, Munna Bhai and Circuit. Munna Bhai is making an offer to Circuit. Munna wrote letter to Circuit. Munna told Circuit, will you buy my bike? Offer. Same time, unknowingly, Circuit also wrote one letter to Munna. Circuit is writing, will you sell me your bike? So can you see this? Both the parties are making offer to each other for the same thing at the same time. Both these offers are called as cross offers. Okay, that is called as cross offer. Now tell me one thing, when both the people are talking about same thing, same time, will this cross offers lead to acceptance? Come on, both parties are talking about same thing, both parties have same intention. So by making a cross offer, will it lead to acceptance? By making a cross offer, will it lead to acceptance? Answer is no. Cross offer will not bind the parties. Can you see this? There is no binding contract in such case, as one's offer cannot constitute as acceptance by other. These are just two different offers, right? They will not be treated as acceptance. It will not be converted into an agreement. It will not be treated as a contract. Okay? I hope this is clear to everybody. Yes. What is next? Next is counter offer. What is counter offer, friends? Counter offer means when a fresh offer is made, ignoring the original offer, it is called as counter offer. The basic example to this is bargaining, right? See, when we go to any shop, so you know the shopkeeper makes an offer. Shopkeeper told us, will you buy this for 500? Shopkeeper makes an offer. Will you buy this for 500? Shopkeeper told us, will you buy this for 500? Offer made by shopkeeper. Now what we did? We accepted his offer? No. We rejected his offer? No. What we did? We ignored his offer and we made a fresh offer. We told him, will you sell this for 100 rupees? We made that offer of 100 rupees. So what we did? We are making a fresh offer, ignoring his original offer of 500. So whenever we make a fresh offer, ignoring his offer is called as counter offer. Okay? So this was one thing. And secondly, in this type, please understand one thing. Whenever we make a fresh offer, original offer comes to an end. Whenever we make a fresh offer, like as I made an offer of 100 rupees, so that offer which he made of 500 rupees shall be discharged. Offer will be lapsed. Yes. So offer comes to an end. Because now he's going to reply for my offer, right? He may say yes, he may say no, he may kill me because I made offer of 100 rupees. That's okay. But the offer which I made 100 rupees, he will be replying for that offer now. Therefore, the offer of 500 rupees shall come to an end. Okay, next is standing offer, open offer, continuing offer. What is this? What is the speciality of this? Okay, speciality is, okay, there is one doubt. No beta, consent is not necessary in cross offer. So it's just that the two parties are making offers to each other. That's it. It's not about consent. These are two different offers. That's it. If you are asking me about acceptance, then yes, consent is required. As I told you, cross offer are just two different offers, right? So cross offer will not lead to acceptance. So as acceptance must be communicated, therefore consent is required in that way. Okay? But for making a cross offer, consent is not required. Come on. The next type of offer is standing offer, which is also known as open offer, which is also known as continuing offer. Okay. Now what is the specialty of this type of offer? The specialty is, this is an offer which is open only for a particular period of time. Yes. Only for a particular period of time. It is called as standing offer, open offer, cross offer. Like for example, the Great Indian Sale, Amazon, 5 days offer. So the offer is open for lifetime? No. Offer is open only for a particular period of time? Yes, that is 5 days. So this offer is open only for a particular period of time. That this type of offer is called as standing offer, open offer, continuing offer. Is this clear to everybody? Yes. Okay, so tell me, who can accept this offer? Okay, any person, as I told you earlier, but this offer can be accepted only within those specific period of time of 5 days. You cannot accept this offer on 6th day because offer is open only for a particular period of time. Okay, so this were all the types of offer. Okay, after types we have lapse of offer. What is lapse? Lapse means comes to an end. Yes, offer comes to an end. Now friends, lapse of offer. In this topic we need to see by what reasons offer is lapsed. By what reasons offer comes to an end. Come on, let's go. First is by revocation. What do you mean by revocation? Revocation means to take back. Come on, listen to me very carefully, okay? Friends, if I make an offer, after making an offer, can I revoke the offer? Come on everybody, listen to me. Don't look here and there. Concentrate, focus here, please. So, once I make an offer, can I take back my offer? Can offer be revoked? Can offer be taken back? Can offer be revoked? Come on, reply me. Can offer be revoked? Yes, offer can be revoked. But offer can be revoked only before acceptance. Offer can be taken back. Offer can be revoked, but only before acceptance. Why? Because once the offer is accepted, it becomes a promise. Yes or no? It becomes an agreement. And once there is formation of agreement, then both parties have to perform their respective obligation. Then you cannot revoke it. Okay. So can offer be revoked? Yes, offer can be revoked, but only before acceptance. So tell me one thing. If I revoke the offer, obviously before acceptance, if I revoke the offer, if I take back my offer, so now tell me, offer is there or offer is lapsed? So in such case, offer is lapsed. Offer comes to an end. By what reason? Revocation. So revocation is the reason. Okay. Come on. Next. Next is by lapse of time. Next is by lapse of time. What is this? By lapse of time, offer comes to an end. By lapse of time, offer comes to an end. What do you think? Yes. In which case it happens? This is possible in case of standing offer. open offer, continuing offer. Yes or no? Yes. This is possible in which case? Standing offer, right? As you know, standing offer is open only for a particular period of time. Once the time is over, offer is also over. So by lapse of time, offer comes to an end. Next is by failure to accept a condition in conditional offer. What is this failure to accept a condition in conditional offer? Come on, do you know conditional offer, everyone? Yes, the offer is made along with the condition. I gave you an example that I will buy your house if you paint the house and give it to me. Yes or no? So friends, if you wish to accept my offer, yes, if you want to sell me your house, can I say you have to paint it and give it to me? Yes. If you wish to accept this offer, you will have to accept the condition also. Because I have not just made an offer, I have made an offer with a condition. So if you, a person, wish to accept this type of offer, you will have to accept the condition as well. So if you fail to accept the condition, offer comes to an end. Because offer is not for you in that case. Because it is not just an offer, it is offer with a condition. Correct. Perfect. Nice. Next is by death or insanity of offerer and offering. Come on, if a person is making an offer, if person made an offer to you, and after making an offer, he dies. Offerer dies after making an offer. So if after making an offer, if a party dies, now what you did, you accepted the offer. But party died. Or party became insanity. He's suffering from insanity now. So tell me now, if you accept the offer now, is there an agreement? So answer is no. If you were aware about his death, if you were aware about his insanity, in that case, there will be no agreement. Offer will be lapsed. Offerer dies, offer also dies. Okay, so offer is lapsed by death or insanity of offerer offering. Okay, yes. But friends, there is one more thing in this. What if he made an offer to you, and after making an offer, party died, offerer died? Okay. Now after that, suppose if you accept the offer in good faith, what if you were not aware about his death and you accept the offer? That means, can I say you have accepted the offer in good faith? Yes. You are innocent party. Yes or no? Yes, it is not your mistake. You accepted the offer in good faith. Now what will happen in this case? So as you accepted the offer in good faith, you were not aware about his death or insanity. What you will say? You will say, what's my mistake in this? I want agreement. I want performance. That's not my mistake. So in this case, can you demand performance of agreement? Yes. In this case, will offer lapse? No. In this case, offer will not lapse. Are you getting the point? Yes, because offer will come to an end only and only if. Offer comes to an end only and only if you were aware about the death and still you accept it. Okay. So in the second one, you were not aware about his death, and if you accept the offer, in that case, as I told you, there will be an agreement and you can demand performance. But from whom will you demand the performance? Party already died. So in such case, you can demand performance from his legal representatives. Okay, so that is the point. But yes, offer comes to an end by death and insanity also. There are chances. And second last one is by counter offer. What do you think? By counter offer, offer comes to an end? Yes. As you know, counter offer, the bargaining part. When the fresh offer is made, original offer comes to an end, right? The bargaining example. So when we made a fresh offer of 100 rupees, so can I say that offer of 500 rupees will come to an end? Yes. So offer is lapsed by counter offer also. And lastly, by rejection of offer. Rejection of offer. What is this rejection of offer? Come on, if I make an offer to you, I am offerer, you are offeree. So if I make an offer to you, and what you did, you ignored my offer. If I made an offer and you ignored my offer, so can I say you rejected my offer? Yes, you rejected my offer. I made an offer, you rejected my offer. So now offer is there or offer is lapsed? Offer is lapsed due to rejection by offering. Okay, so these are the 6 points. for lapse of offer. Come on, what is next? Definition of acceptance. What is this? Acceptance, yes. See, with this we have done with all the four things of offer, right? That is definition, characteristics, types and lapse. With this you know what is a valid offer now, but only valid offer is not enough. Along with valid offer, there must be valid acceptance as well. Okay, so let's see now what is acceptance. In acceptance there are only two things, that is definition and characteristics, that is features. Okay, come on. So offer was defined in section 2 subsection A. Similarly acceptance is defined in section 2 subsection B. Can you tell me who accepts the offer? Offerer or offeree? Obviously offeree. Offeree means person to whom the offer is made. So if person to whom offer is made, if that party gives the assent means gives his approval to your offer, can I say that offer is accepted? Yes. So when the party to whom the offer is made, if gives his acceptance, if gives his assent to your offer, gives his approval to your offer, it is said that the offer is accepted. And can I say when the offer is accepted, it becomes dash? Come on, tell me, it becomes what? When the offer is accepted, it becomes dash. Come on, answer me. It becomes dash. It becomes what? Come on. When the offer is accepted, it becomes what? Answer me fast. It becomes what? When the offer is accepted, it becomes dash. What does it become? Come on, everyone. Correct. It becomes a promise. Many of you may write agreement also, but as per the definition, it is a promise. And you know, promise is another word for agreement. Okay. So yes, when the offer is accepted, it becomes a promise. Okay, done? Yes. Good. Nice. Active audience. Superb. Good job. Okay, there is one doubt. Arshita is writing something. In conditional offer, the offerer accepts the offer, isn't it? Beta, in conditional offer, offerer. How offerer will accept the condition, beta? How offerer will accept the offer? No. See, if it's a conditional offer, I am making an offer to you along with a condition. I told you I will buy your house if you paint the house and give it to me. So I am offerer, you are offeree. Yes or no? I am offerer, you are offeree. Now if you wish to accept my offer, you will have to accept the condition also. Now suppose if you accept my offer with a condition, so who are you? You are offeree only. Are you making an offer? No, I am making an offer. Beta, offeree doesn't put the condition. Offerer puts the condition. There is some error in your preparation, I guess. How offeree will put the condition? Conditional offer means offer is made along with the condition. The person who is making an offer makes an offer with a condition. Okay, so that is where it is. Come on, let's go further now. So friends, yes, acceptance. We did the definition. Now characteristics. Come on, why are we studying the characteristics first? So friends, importance of features is we need to understand what is a valid acceptance, right? So when can you say acceptance is valid? So here are the points. Acceptance must be as per all these points. Okay, first point. Acceptance must be communicated. Yes, what is this? See friends, if you make an offer to me, if you send me a letter of offer. So if you are sending me an offer letter, what I did, I opened the letter, I liked the offer, I signed it, I wrote accepted, and then I folded the envelope and I kept this envelope in my bag. Come on, tell me, is this a valid acceptance? Is this a valid acceptance? Answer is no. This is not a valid acceptance. Why it is not a valid acceptance? Because I have not communicated my acceptance to you. I have not communicated my acceptance to you. Are you getting my point? Yes. Everybody understood? Because acceptance must be communicated. Okay. Next is, acceptance must be communicated by a person who has authority to accept it. Friends, tell me, who can accept the offer? Who can communicate the acceptance? Acceptance must be communicated by a person who is having authority to do that. Tell me, who is having authority to accept the communication? Come on. Who is having authority to communicate the acceptance? Who is having authority? Can I say offeree is having the authority? Yes. So if I'm making an offer to you, I'm offerer, you're offeree. Can you communicate the acceptance? Yes. So what you will do is, you will communicate the acceptance. So offeree is the right person to communicate the acceptance? Yes. Tell me, can your agent do this? Yes. You know who is an agent? Agent means a person who is acting on your behalf. Person to whom you have given the authority to act on your behalf. Agent means person who acts on behalf of another. Okay? So, who can communicate the acceptance? Acceptance must be communicated by offeree or his agent and no one else. Okay? So that is the point. Next is, acceptance must be absolute and unqualified. It means acceptance must be unconditional. Acceptance must be unconditional. When you are accepting an offer, it has to be unconditional. You have to be like, yes, I agree to the offer. You can't say, I accept the offer if you do this, if you do that. No, that is not allowed in case of acceptance. Obviously, in offer we have studied, offer can be conditional, but acceptance cannot be conditional. When you are replying to an offer, that means you are accepting an offer. So when you are accepting an offer, your acceptance cannot be a condition. Why? Because conditional acceptance is a counter offer. Conditional acceptance is a counter offer. Because when you are replying to an offer, and if your reply is a condition, if your reply is conditional, that means what you are doing is, you are making a counter offer. You are ignoring my offer and you are putting a fresh condition for which now I have to reply. So, conclusion is, whenever a person is making an offer, and if you wish to accept it, you have to accept it in unconditional manner. Your acceptance cannot be conditional. Okay? I hope this is clear to everyone. Let's go further. Yes, next is, acceptance must be within a specific time or reasonable time. Acceptance must be within specific time or reasonable time. See, you have studied standing offer, everyone. So standing offer is an offer which is open only for a particular period of time. Example, 5 days, Amazon sale, 5 days, right? If you want to accept this type of offer, you can accept the offer only within specific period of time. Because such an offer comes to an end with time. Correct? So must be within specific time. If it's a standing offer, you have to give your acceptance within the given time only. But friends, tell me one thing. All offers are standing offers? All offers are standing offers? No. There can be offers without time limit also. So tell me, if time is not specified in the offer, when can you accept it? By when can you accept it? Because just now I took example that was for the time is specified in the offer. So if the time is specified in the offer, acceptance must be within specified time only. Right? But what if the time is not specified in the offer? Then what to do? If time is not specified, in that case, you can accept the offer within reasonable time. You can accept the offer within reasonable time. Because time is not specified in it. Now your doubt is, what is reasonable time, correct? So friends, reasonable time is not defined in law. Reasonable time is not the matter of law. Reasonable time is the matter of fact. That differs from case to case. Means it depends on the circumstances. It depends on the circumstances, like what is the subject matter of contract, like what we are talking about. It depends on that. Okay, so reasonable time. and specific time. Clear everybody? Yes. Next is then acceptance can be express also, implied also. You know what is the meaning of express and implied, right? Express means same use of words, oral, written. So can you give your acceptance orally? Yes. Can you give your acceptance in writing? Yes. Both these are called as express acceptance. But you know you can accept the offer in implied manner also. You can give your acceptance in implied manner also. That is by the act of party. That example which I took, that bus comes and takes a halt at the bus stop. This act done by the bus service provider, taking a halt at the bus stop, means they are, what they are doing? They are offering a bus ride to the passengers waiting at the bus stop. Now tell me, the offer which is made, this is an implied offer? Yes. How to accept this offer? Very simple. We can accept this offer just by boarding the bus. If I board the bus, if I take the bus, then what will happen? That means can I say I have accepted that offer in implied manner? Yes, just by the act done by me. Boarding the bus was acceptance, implied acceptance. Okay, tell me, is it necessary for me to board the bus? No, it is my choice. So obviously, it is not necessary for you to accept all the offers. But if I want to accept this offer, how can I accept it? By boarding the bus. Everybody understood? So acceptance can be expressed also, implied also. And for implied acceptance, there is a famous case law, Lillywhite versus Manuswamy. You can read that. Next is, acceptance should be via prescribed mode of communication. What is this? Acceptance must be in the prescribed mode only. Everyone, are you listening? Just write yes, everyone. Come on in the chat box. Are you all with me? Are you going to attend both the chapters today along with MCQs? Yes, we will do everything today. We will cover everything today. You have to be present just today. You have to give some time today. We will finish everything. Are you all listening? Everyone? Are you going to attend one chapter or both the chapters? Are you going to attend full session or half session? Come on, write it down. Tell me. Yes, yes, yes. Your words motivate us. Come on. Everyone, are you there? Yes, yes, yes. Okay. Great. Okay, let's go. So, acceptance must be via prescribed mode of communication. What is this prescribed mode of communication? See, for example, if I make an offer to you, if I give you an offer and I told you clearly that if you wish to accept my offer, give me your acceptance in writing. If you wish to accept my offer, give me your acceptance in writing. So tell me, in my offer, have I prescribed some mode? Yes, I have prescribed the mode. What is the mode? That you have to give me your acceptance in writing. Written mode. I have prescribed the written mode. Okay? Now friends, if you wish to accept this offer, what you will have to do? Come on, your acceptance must be in the prescribed mode only. Come on, I have told you that give me your acceptance in writing. But what you are doing? You gave me your acceptance. You gave me your acceptance orally. Tell me, if you give me your acceptance orally, then what will happen? Is this a prescribed mode? No. The point says that acceptance must be in the prescribed mode. I have prescribed my mode, that is, you have to give me your acceptance in writing. Therefore, you have to make it in writing if you want to make a valid acceptance. Okay? But what you did, you gave me your acceptance in some other mode. So if you give me your acceptance in some other mode, is this a valid acceptance? So answer to this is, there is further question in this case. Yes. What is the further question? Come on. Acceptance must be in the prescribed mode. You gave me your acceptance in some other mode. You gave me your acceptance orally. But now, what if? So generally it is not a valid acceptance, right? But what if now offerer is okay with it? What if offerer is okay with it? What if offerer have no problem with this other mode? Then what to do? Is that okay? What if offerer is okay with it? Offerer is having no objection to accept it now orally. Any problem? So friends, if offerer is having no objection, then this will also be treated as a valid acceptance. Okay, so this is the point. So we are done with all the features of acceptance as well. Okay, so now I hope you know what is a valid offer, what is a valid acceptance. Okay, then we have a small topic about communication of offer and acceptance. Okay, so yes, for this you already have your notes, right? When can you say, see, offer and acceptance, right? Very, very important topic. So for this, here there are 4 rules basically. First is about completion of offer. Then it is about revocation of offer. These 2 points, okay? So come on, if one person is making an offer, I have made an offer to you. So tell me, when can I say that the offer is completed? If I make an offer to you, when can I say the communication of offer is completed? So communication of offer is completed when the offer comes to the knowledge of offeree. Yes, when you come to know about the offer, offer is said to be completed. That is the first point. Communication of offer is completed when it comes to the knowledge of offeree. When it comes to the knowledge of offeree. I hope this is clear. Yes, second point. Yes, that is actually the third one. Now we are talking about revocation of offer. Come on, after making an offer, can I revoke it? Can I revoke the offer? Yes, as you know, offer can be revoked. But offer can be revoked only before acceptance, right? What is acceptance? How can you accept it? So obviously if you wish to accept the offer, you have to communicate your acceptance. Yes or no? Yes. So what you will do? You will write it accepted and you will post your letter. Yes or no? Yes. So I can take back my offer before acceptance. And what is acceptance? Putting the letter in transit is acceptance. Right. So revocation of offer is valid before offeree puts the acceptance in transit. Yes. Before you put it in transit, I can revoke my offer. So I hope this is clear to everyone. This was about communication of offer and revocation of offer. Now we will talk about communication of acceptance and revocation of acceptance. Okay, let's see what it is. So friends, if you posted your letter of acceptance, so when can we say that the communication of acceptance is completed? When can we say that? So communication of acceptance is completed against offerer. Yes, against offerer. When can you say that? As soon as you put the letter in transit, your job is done. As soon as the offeree puts the acceptance in transit, your job is done. That means now, can I revoke my offer? No. Because offer can be revoked. If we have done this here, offer can be revoked only before offeree puts the acceptance in transit. Yes or no? Yes. So why I can revoke my offer only before you put it in transit? Because once you put it in transit, acceptance is done for you. Now nobody can do anything. Now offerer cannot do anything. Therefore it is against offerer. Therefore it is against offerer. Okay, yes, so that is the point where acceptance is said to be completed against offerer. But what about against offeree? Yes, you know, once the offeree puts the acceptance in transit, now offer cannot be revoked, right? Because offer is completed. Yes, acceptance is completed against offerer. But once offeree puts the acceptance in transit, after that, can acceptance be revoked? Can acceptance be revoked? Yes or no? So answer is yes. Acceptance can be revoked. Are you getting the point? Yes, acceptance can be revoked. Because acceptance is said to be completed when it comes to the knowledge of offerer. When it comes to the knowledge of offerer. So this is the point where acceptance is completed against offeree. So if we conclude this, if offeree puts the letter of acceptance in transit, now offer cannot be revoked. Because acceptance is said to be completed as soon as the offeree puts it into transit. Okay, but once the offeree puts it in transit, can acceptance be revoked? Yes. Offeree can revoke the acceptance before acceptance comes to the knowledge of offerer. So these are the 4 points, right? Yes. Next. After this topic, now there are types of contracts. Let's go everyone. Types of contracts. Very simple. So friends, what are the different types of contracts? First type we can see is a valid contract. What is valid contract? Very simple. Contract is an agreement. A valid contract is an agreement which is enforceable by law. But friends, which agreements are enforceable by law and which are not? Which agreements are enforceable and which are not? So friends, an agreement which fulfills all the essential elements for a valid contract, such an agreement is enforceable by law. Such an agreement is called as a contract. You know there are essential elements for a valid contract? See here there are. See here it is. Can you see this? Essential elements for a valid contract. Here there are 10 points. When all these points are getting satisfied, 10 points are getting satisfied, if all these 10 things are present in your agreement, then this agreement becomes a contract. Then this agreement can be called as a contract. Then this agreement is enforceable by law, okay? So yes, that is a valid contract. That is an agreement which is enforceable by law. Second is void contract and void agreement. Now void means what? Not enforceable by law, obviously. Now here there are two terms you saw. One is the contract and another is agreement. So when we say void contract, what it is? It is a contract which is not enforceable by law. Okay, and if we say void agreement, then it is an agreement which is not enforceable by law. Contract which is not enforceable by law, and this is agreement which is not enforceable by law. Okay, yes. Now friends, what is the difference between two? Both are not enforceable by law. Difference is, the first one you saw, this was a contract earlier. This was a contract in the beginning and later on it became void. And this is agreement which is not enforceable by law, means it was not a contract. This was never a contract. This is void from the beginning. This is void ab initio. This was never a contract. So that is the difference between void contract and void agreement. Okay, this one was never a contract. This was a contract in the beginning. Later on it became void. Example for this one is void ab initio, agreement with minor. Example for this one is supervening impossibility. Okay. Okay. Next type is voidable contract. You know what is voidable contract? Voidable contract means it is a situation which is not valid right now, not even void right now. This is a contract which can be valid, can be void. It depends on the other party. It is at the option of other party. It is at the option of aggrieved party, that is suffering party. Are you getting it? Yes. So that type of contract is called as voidable contract. So it is an agreement which is right now not valid, not void. This can be valid, can be void. It depends on the option of other party. Examples are coercion, undue influence, right? Fraud, misrepresentation. All these are voidable in nature. That is at the option of aggrieved party. Aggrieved party means suffering party. Yes. After voidable contract, next we have is illegal agreement. What is this illegal agreement? So here you can see the word used is agreement. Agreement which is illegal. Now tell me one thing. Illegal agreement means what? Illegal agreement means what? Enforceable by law or not enforceable by law? Obviously it is not enforceable by law. Agreement which is not enforceable by law. Okay. But friends, you saw here also I wrote agreement which is not enforceable by law. Here also I am saying agreement which is not enforceable by law. So what is the difference between two? Difference is void agreement is just not enforceable by law, but friends, illegal agreement is not enforceable by law, plus it is punishable by law. Illegal agreement is punishable, void agreement is not punishable. That is the difference. Okay. So can I say all illegal agreements are not enforceable? Means all illegal agreements are void, but all void are illegal? All void are not illegal. Example, agreement with minor is void, right? Void ab initio means it's void, but it is not illegal, it is not punishable, right? Void just means that if you want to do contract, you do it. If anything goes wrong, law will not help you. That is not enforceable by law. But if you do something which is illegal, then it is not enforceable by law, plus it is punishable by law. Yes, come on. Next type of contract is unenforceable contract. What is unenforceable contract? Unenforceable contract. Firstly, the word you can see here is, here the word used is contract. Contract which is unenforceable means not enforceable by law. So contract which is not enforceable by law. But friends, you saw here also I wrote contract which is not enforceable by law. In void contract also I wrote the same thing, contract which is not enforceable by law. So void contract, contract not enforceable by law. Unenforceable contract, contract which is not enforceable by law. So what is the difference between two? Difference is, when we say unenforceable contract, means it is a contract which is not enforceable by law due to technical defect in the contract. Can you see this? Due to some technical defect in the contract. Example, if suppose we both enter into a written contract. If we both are entering into a written contract, all the terms and conditions are written on the contract paper. Now we both have to sign it. So now what happened? You have signed the contract, I have not signed it. Okay, now obviously it doesn't mean that I don't agree to those terms. I agree to those terms. I agree to all the terms. But I have not signed it. So friends, if I have not signed it, that means can I say signature of one party is missing on the paper? Yes. Maybe by mistake, or it is we forgot, or whatever the reason is, but I have not signed it. One party has signed, other party has not signed. Okay, so now what we did, we kept the contract paper in our cupboard. Now in future there was a dispute between both of us. Now we took this paper, contract paper, to court. What will court see? And court will say that, oh no, signature of one party is missing. So if signature of one party is missing, that means this is not a valid contract. This contract cannot be enforced by law. This contract cannot be supported by law. Why cannot be supported by law? Because there is some problem in the contract. There is some defect in the contract because signature is missing. Similarly, you know, when you buy property, when you buy house, when you sell house, there are agreement papers, green papers, right? Now, in that case, whenever you buy a property or whenever you sell the property, you always have to go for registration to the registrar. You have to pay stamp duty. You have to do signing, stamping and everything, right? But friends, now tell me one thing. You don't have to sign it. You have to go for registration. You have to stamp, sign and everything, right? What if in that case registration is pending? Both the parties have signed it, but it is not registered. Will that be treated as a valid contract? No. Can I say there is some problem in the contract? Yes. Other everything is okay, but there is some technical defect in the contract. This can also be the example. Then if the agreement is not prepared in a proper format, then also it's a technical defect. So all these contracts are called as unenforceable contracts. Okay, now next is express contract. You know very well, it is all, you know, oral or written contracts are called as express contracts. Implied contracts, again it is by the act of party. Yes, it is just by the act of party, no use of words, is called implied contracts. Then there is something called as tacit contract. Now when we say tacit contract, again the explanation of tacit contract you will see that is similar to implied contract. Can you see this? It is by the conduct of party. Yes, contract is formed by the conduct of party, that is by the act of party. Same thing we discussed in implied contract also. So why both the points are having same explanation? That is because tacit contract is a part of implied contract only. Therefore, formation of contract is by the conduct of party. Okay, so therefore it is having the same explanation. Then next is executed contract and executory contract. What is executed contract? Executed means it is a contract in which both parties have already performed their obligation. Performance is done. So contract is executed or executory? It is executed contract. So can I say a contract which is discharged by performance is called as executed contract. Okay. Then executory. It is a contract in which parties still have to perform. Parties still have to perform. It's called as executory contract. Okay. Then unilateral contract and bilateral contract. You know very well what is the meaning of the word unilateral. Unilateral word means what? Unilateral word means one party. Bilateral word means what? Both the parties. So you know unilateral contract is a contract in which only one party has to perform as obligation. It is a contract in which only one party have to perform. It's called as unilateral contracts. But sir, we have heard that in a contract always both party have to perform. That is not the case always. Obviously in the majority cases both parties have to perform, but there are unilateral contracts also. Example is all the exceptions of no consideration, no contract. All those are unilateral contracts. Okay. Then next is bilateral contract. So as I told you, bilateral means both the parties. So bilateral contract means a contract in which both the parties have to perform their obligation. Yes, such contracts are called as bilateral contracts. Generally, all the contracts are bilateral contracts. Generally. Okay. Is this clear to everybody? All the types of contracts are done here. Okay. But now here we have something called as types of contracts as per English law also. Types of contracts as per English law. So there are only two types. One is formal contracts and simple contracts. The formal contracts are divided into two categories: contract of record and contract under seal. What is contract of record? Contract of record is nothing but Quasi contracts. You know the Quasi contract which we did in class? So in Indian law, the Quasi contract is called as contract of record in English law. If you see the explanation of this type, you will see it is similar to Quasi contract. Like it is not a contract in real sense. Parties have no intention to enter into a contract, but still they can create a legal obligation, all these things. Okay, the next is contract under seal. What is contract under seal? All written contracts which are signed, stamped, right? All these are called as what? Contract under seal. Okay? Yes. All written contracts are called as contract under seal. So these two categories were about formal contracts. Okay. Next is simple contracts. So all other contracts are called as simple contracts. Easy? Yeah. So we are done with all the types of contracts. Okay. Now, after this, what's next? Next topic is, and last topic to finish our unit number 1 is essential elements for a valid contract. What is essential elements for a valid contract? See, when we have a doubt that which agreements are converted into contracts and which are not, so you have to just check this topic. When agreement is having all these ingredients, this agreement will become a contract. Let's see what all things are essential to make an agreement enforceable by law. First you need is offer plus acceptance, very basic. Then you need mutual consent of parties. means both parties should agree for same thing. Meeting of minds. There is a Latin maxim, can you see here? Consensus ad idem, which means meeting of minds. Consensus ad idem, meeting of minds. Yes, that means, like for example, if I agree to sell my phone to you, you should agree to buy my phone. So both parties should have common interest, common meeting of minds. That is called consensus ad idem. Basically, two parties enter into an agreement. So that is also essential element. Okay. Third, there must be a legal obligation. What is legal obligation? As I told you in the offer must create legal obligation. In that case law, you saw Belfer versus Belfer. Offer was not creating legal obligation. You know, we make so many agreements with our friends. I told you, are you coming for a movie with me? Offer. You told, yes sir, let's go, we are coming. And then you didn't appear. You didn't came. You accepted my offer. There was agreement between parties, but you didn't follow the agreement. Come on now, tell me, can I sue you? No. Why I cannot sue you? Because this agreement is not enforceable by law. Why it is not enforceable by law? Because offer made by party is not creating legal obligation. Therefore, all agreements are not contracts. So if the offer made by party is not creating legal obligation, that means that agreement is nothing but social agreement. That agreement is social agreement. And social agreements are never ever enforceable by law. Social agreements are not enforceable by law. Therefore, legal obligation is necessary. Okay. Next is, there must be free consent of parties. You know, there is a topic on free consent. Yes, when you enter into a contract, only consent is not enough. You have to give your free consent. Means you have to enter into a contract by your own will, not because of any pressure. Next is, parties who enter into a contract must be competent to contract. As you know, there are few parties who are not allowed to enter into a contract. Okay, so basically you have to enter into a contract with a person who is legally allowed to enter into a contract. Next is, agreement must be supported by lawful consideration. Yes, agreement must be having a lawful consideration. You know what is consideration? Consideration means something in return. Yes. You know, when two parties enter into a contract, both parties should get something in return. Both parties should have something in return. That is essential element. Then next is, the object of agreement must be lawful. The purpose of your agreement must be lawful. You can't enter into a contract for illegal things. If you're doing that, you know illegal agreements are not enforceable by law. Next, agreement must not be declared as void. You know friends, in your Indian Contract Act, there are few agreements which are declared as void. What is declared as void? It is announced as void. There are few agreements which are announced as void, declared as void. Yes. So there are 5 agreements which are declared as void. We will be doing that topic, don't worry. But friends, if you enter into a contract, if you enter into an agreement which is already announced as void, come on, tell me, will you enter into a valid contract? No. So whenever you are entering into a valid contract, make sure that you don't do an agreement which is already declared as void. There are 5 agreements which are declared as void. I will be revising that when we reach to that topic. Okay. Next is, make sure that agreement is certain. Agreement must be certain. Means agreement must be clear. Okay. Yes. Like see, if you enter into an agreement, both the parties must be clear about their obligation. Both the parties are very much certain that what they have to perform. So agreement must be certain. And lastly, performance must not be impossible. What is that? Performance must not be impossible. See, whenever you enter into a contract with someone, the performance of agreement must be the possible one. Like, I can't give you an offer like, come on, I will give you 100 crore rupees if you count the number of liters of water in the Arabian Sea. Yes. If you count the total number of liters of water in the Arabian Sea, if you count that, I'll give you 100 CR. Tell me, is it possible? No. So performance must not be impossible. Sorry. Because if you enter into an agreement, performance of which is impossible, all impossibility agreements are totally void. Okay? But here we are talking about a valid contract, so performance must not be impossible. Done with this? So these are the 10 ingredients to make a contract valid. Okay? Yes. Please learn all of these. Very, very important. And after this, we have a small topic, that is contracts over telephone. You know, friends, we did that topic, communication of offer and acceptance. Right? Those 4 rules. So what if we do communication over telephone? When will offer be completed? When acceptance will be completed? How can offer be revoked here? What is the rules? So here they are saying that if the contracts are done over telephone, same rules are applicable. If contracts are done over telephone, same rules are applicable. Which rules? The same rules which we did over there. Those 4 rules. Communication of offer and acceptance. Okay, it is just that here the communication is done over telephone, means here the offer will be completed on the spot. That is the only difference. Otherwise, same rules are applicable which we did in that case. Okay, so friends, with this we have completed with our unit number 1. Okay, yes, total we are going to go with 7 units. Unit 1 is over. I hope this is helpful. I hope you all are getting the benefit of it. Yes, no, everyone. If you're getting the benefit, if you want me to revise all the topics in this way, so if you can just give a like to this video. Okay, so then yes, and now we can go to the next unit, unit number 2. Okay, unit 1 is over. Unit 2 begins. Yes, that is consideration. Unit 2 is consideration. Okay, now friends, unit number 2, consideration. Back. Now friends, what is consideration? Firstly, the meaning of consideration is something in return. Yes, what is the meaning? Something in return. Consideration means something in return, okay? And here also we have a Latin maxim, that is quid pro quo. Consideration means quid pro quo. Okay, which means something in return. Friends, you know, just now we did that essential elements. In that essential elements you saw that lawful consideration is required to make a contract valid, right? So that is the topic about consideration. You know, whenever the 2 parties enter into a contract, both parties should get something in return. Both parties should get consideration. Both parties should get something in return to each other. Like for example, if we both enter into a contract regarding sale of my mobile phone. So if we both enter into a contract regarding sale of my mobile phone, there is offer plus acceptance, there is an agreement. Come on, tell me, if I'm selling my mobile phone to you, tell me in this contract, what is consideration for you? Are you getting anything in return? Yes, you are getting mobile phone. Am I getting anything in return? Yes, I am getting money. So both parties are having something in return here. So that is essential. Because consideration is an essential element for a valid contract. Consideration is an essential element for a valid contract. Are you getting my point? Yes. Because no consideration, no contract, No contract. As you know, consideration is one of the essential elements for a valid contract. So this is the essential ingredient, right? So if this is not present in an agreement, it is not a contract. It is not enforceable by law, right? As you know, it was one of the essential elements for a valid contract. So what is the rule? Rule is no consideration, no contract, no contract. Yes or no? Yes. So in this unit 2, we are going to talk about consideration. So here there are 4 topics related to consideration. Yes. Which are the 4 topics? 4 topics are: one is definition of consideration, then we have features of consideration, then we have a topic that is called as no consideration, no contract, and the last topic we have is doctrine of privity. Okay, now obviously friends, I assume that you people have already uh, read everything once, and today we are doing this revision point of view. Okay, yes, let's go. So definition. So friends, consideration is defined in what? Obviously section 2 subsection D. Section 2 subsection D. Okay, done. Now friends, the consideration is quid pro quo, something in return, defined in section 2 subsection D. What are the characteristics? What are the features? Because as I told you, both parties should get something in return. But it is not just that both parties should get something in return. That consideration what party gets must be a valid consideration. You don't just you don't just have to get the consideration, you should get the valid consideration. So when can we say consideration is valid? When we satisfy all the requirements, all the features of consideration. Let's see what is a valid consideration. First, consideration must move from as per the desire of promisor. Friends, you know who is a promisor? The offerer is called as promisor. Offeree is called as promisee. Okay? Yes. So here the point says that consideration must move as per the desire of promisor. Promisor means offerer. So always whatever the offer is made, if you accept the offer, okay, like for example, if I told you that, will you buy my phone for 10,000 rupees? Come on. You said yes, okay, done. So you give me 10,000 rupees, I give you my phone. Tell me who decided the consideration? Offerer. Always it is as per the desire of promisor only, that is offerer only. So that is the point here. You know, even in case of counter offer, like if I say you that, will you buy my phone for 10,000? It is not always necessary that you will accept it. You may give a counter offer also. You may say that, okay, do one thing, will you give it in 6,000? If you do that and if I say yes, so now tell me who decided the consideration, offerer or offeree? You will say offeree. No. Here also it is as per the desire of offerer only, promiser only. How? Because when you gave me that offer of 6,000 rupees, when you told me, will you give me that 6,000 rupees, that means you are making a counter offer, yes or no? You are making a fresh offer, ignoring my original offer, yes or no? Yes. So friends, when you are making a fresh offer, that means now you are making an offer. So if you are making an offer, who are you? Now you are offerer. Now you are promiser. Yes or no? Yes. So therefore now it is as per the desire of promiser again. So in every example you will see consideration is always as per the desire of promiser. Okay, done? So that is the first point. Here there is a famous case law, Durga Prasad versus Baldev. Okay. Next, second requirement, a second feature is consideration may move from promisee or any other person. Means in a contract, party can get consideration from promisee, means the person with whom I have entered into a contract. So I can get something in return from you or from any other person. Important is I should get something in return. Right? It can be from promisee or from any other person. Okay, anyway. This was explained in the case law Chenaya versus Ramaya. Okay, also I can give you one more example. Like if I go to police station to file a complaint. Okay, so I told policeman that will you please accept my complaint. He said yes, 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 why not. So I gave an offer, he accepted my offer, there was an agreement. So now it is his duty to provide service. I told him, can you please provide service now? Complaint is already registered. He's saying no, but I am not getting something in return from you. No consideration, no contract. I am not getting anything in return from you. So therefore no consideration, no contract. Consideration is an essential element, is saying me. So tell me friends, is consideration missing for him? Obviously I am not giving him anything. If I give anything to him, it will be a bribe. Yes or no? So if, so now you tell me please, can I say consideration is not missing here? Is consideration missing for policeman? What do you think? Obviously he is not getting anything in return from me, but is he getting his salary from government? Yes. To provide these services? Yes. So he is getting consideration not from the promisee but from other person. So therefore, as the consideration is not missing, it is a valid contract. It is a valid consideration. It is coming from promisee or any other person. So important is that consideration should be there. Only that is important. Okay. Yes. Yes. Next. Now, what is next is consideration can be past, present or future. There's something in return what you get that can be past also, present also and future also. Very simple point, right? Yes, it can be past also. You have already received something, now you have to provide service. So whatever you have already received in past, that is a valid consideration. That is possible in case of credit sales. Then consideration can be present also. This is possible in case of cash sales. When we go to a shop, we buy something, we give him money, he gives us some goods. So both the parties are getting consideration on the spot. That is in present. Third one, future. What is that future? That is, let's say for example, if I promise to provide you some services in future, kindly make the payment today. So if you book your seat today and I agree to provide you service in future, will you pay me today? Yes. So you have paid me something today, you have paid some amount today for the consideration which you are going to get in future. So consideration can be past also, present also and future also. But I hope you know, as per English law, in English law, past consideration is no consideration. In English law, they don't consider past consideration as valid consideration. Okay. Okay. Here there is a doubt. Yuvraj, the question what you are asking is from unit number 4. That is about performance of contract. So we will come to that part, unit 4. Okay, to avoid confusion, I would request you if you can ask me this when we reach to unit 4. Okay, we'll discuss it. Because your question is about performance of contract. Okay, next point. Consideration need not be adequate. Means whatever we get in return, even if that is not adequate, means even if it is not sufficient, that's okay. It should be there. Because consideration is an essential element. It should be there. So you cannot, even if it is not sufficient, okay, if I sell you my property, if you sell you my big property for 10 rupees, so tell me what are you getting? You are getting property. What I am getting? 10 rupees. So tell me, 10 rupees what I am getting, is this a valid consideration? Yes, it is a valid consideration. Because consideration need not to be adequate. Means consideration is not required to be adequate. Even if it is not adequate, even if it is not sufficient, it's okay, it is valid. Okay, done. Next, consideration must be real and not illusory. Consideration must be real and not illusory. Illusory means imaginary. Means whatever you are getting in return, that must be real and not imaginary. Like for example, you pay me 10 lakh rupees, I will give you blessings. Come on, what are you getting? You are getting blessings. Tell me, blessings are real or imaginary? It is illusory, imaginary. Therefore, that is not a valid consideration. Okay, so consideration has to be real and not illusory. Then, whatever consideration you are getting, that consideration must not be illegal, immoral, and opposed to public policy. Whatever you are getting in return. Like for example, if I promise to sell you drugs tonight, if I promise to deliver you drugs tonight 9 p.m., tell me, what is my obligation? My obligation is to deliver you drugs. What is your obligation? Your obligation is to make the payment. Tell me what I'm getting in return. I'm getting money. What you are getting drugs. Tell me, can I say consideration what you are getting is illegal? Yes. Therefore, it is not a valid consideration. So, consideration must not be illegal, immoral, and opposed to public policy. The example for opposed to public policy is bribe. Obviously, bribe. The person who is taking bribe, what is he getting in return? He's getting bribe, means he's getting money. So whatever money he's getting as a consideration, is that a valid consideration? No, it is opposed to public policy. Sir, why it is opposed to public policy? Bribe is opposed to public policy. Why? Because if the bribe is valid, then there will be a big problem. If bribe is valid, there will be a big problem. What big problem? Friends, if bribe is valid, then it is like whoever gives bribe can do anything. So therefore, bribe is opposed to public policy. So whatever you get in return must not be illegal, immoral, and opposed to public policy. Then, consideration can be executed or executory. What is executed or executory? Means if party has already given the consideration to each other, such consideration is called as executed consideration. Because parties have already given consideration to each other. It's called executed consideration. Okay. Secondly, if parties have to perform, if parties still have to perform, then it is called as executory consideration. It is executed and executory. Okay. Yes. Then consideration can be positive or negative. What is this positive or negative? You know, friends, we can enter into an agreement for doing something, and we can also enter into an agreement for not to do something as well. We can enter into a contract for doing something. We can enter into a contract for not to do something as well. Like for example, if I offer you some money, if I told you, keep this money, please do this for me. So in this agreement, tell me what is consideration for me? That you do that. So in this case, tell me what is consideration for me? That you do that. This is called positive consideration for me. But what if we enter into an agreement for not to do something? If I offer you some money and if I tell you don't do this, take this money. So in this case, tell me what is consideration for me in this case? Consideration for me is that you don't do this. Are you getting it? So friends, in this case, consideration for me is that you don't do this, right? So in this case, it is called as negative consideration. So here, positive and negative does not mean legal and illegal. Here, positive negative means to do something agreement, and negative means agreement for not to do something. Okay? Yes, both can be valid. Next is consideration for an act which a person is legally bound to perform is not a valid consideration. Yes, consideration for an act which a person is legally bound to perform is not a valid consideration. What is this? See, you are giving something, consideration for an act. You are giving, like for example, you went to police station to file a complaint. Now that policeman was not writing the complaint because he wants bribe. Okay, so now if you give him bribe, can I say you are giving him something in return? Yes. So whatever bribe amount you give him, Whatever amount you pay him, what is that? You are paying him for what? For filing a complaint. Can I say you are paying him for filing a complaint? You are paying him for an act which he is already bound to perform. So whatever you are giving him is not a valid consideration, because he was bound to do that, even if you don't give him time. So consideration for an act which a person is legally bound to perform is not a valid consideration. Okay, so I hope this is clear to everybody. These are the 9 features. Yes. Nine features of consideration. Everyone is clear with this? Everyone, yes, no? 9 points. Yes, so now in unit number 2, out of 4 topics, 2 topics are done. Next, what we are going to do is 2 remaining topics, then unit 2 is over. Okay? The remaining 2 topics are, one is Doctrine of privity and another is no consideration, no contract. Okay? Yes, so first we are going with this topic, no consideration, no contract. Come on, looking at the title, everyone, what do you think? Have you understood the title? No consideration, no contract? Yes. No consideration, no contract, no contract. If there is no consideration for parties, there is not a contract. Because consideration is an essential element for a valid contract. If there is no consideration, there is no contract. Okay? So that is the basic rule which I told you just now. No consideration, no contract. Okay? If parties don't get something in return, it is not a valid contract. Okay? Fine. So I hope everyone is clear with this. No consideration, no contract. Okay? But there are few exceptions. There are few exceptions to this rule. What are the exceptions? There are total 7 exceptions. Means I am going to talk about the circumstances where there is no consideration, but still it is a valid contract. There are no consideration, but still it is a valid contract. So general rule says that if there is no consideration, there is no contract. Okay? But in exceptions, in 7 points, you will see that there are few exceptions which are saying that even if there is no consideration, it can be a valid contract. So which are those 7 exceptions? So here you can see, out of natural love and affection, right? Then compensation paid for past voluntary service, right? Then promise to pay for a debt which is barred by limitation, creation of agency in case of gifts and bailment and charity. These are the 7 points, right? 7 exceptions. But I hope you know the first one, out of natural love and affection, becomes an exception if 4 conditions are getting satisfied. This point becomes an exception if 4 conditions are getting satisfied. Which are the 4 conditions? The 4 conditions are, this becomes an exception if the agreement is in writing, right? Then it is signed by the parties. Agreement is registered. Okay. And there is natural love and affection. Agreement was made out of natural love and affection. Only then this becomes an exception. The first point. Okay. Then second one was compensation paid for past voluntary service. If you give some service out of your own will, without any consideration, if you're giving some service, and for that service, like for example, if you found some missing purse and you return it to the owner, so you did it by your own will, and out of happiness that person makes a promise to you that I will pay you so and so amount because you helped me. So that promise made to you is a valid contract, Here, as per the exceptions, if the two conditions are getting satisfied, that promise must be in writing, and secondly, it must be for past voluntary service. Okay. Third one, promise to pay for a debt which is barred by limitation. Yes, what is this promise to pay for a debt which is barred by limitation? You know, whenever there is a contract between two parties, and if anything goes wrong in the contract, can parties sue each other? Yes, parties can sue each other, but there is a limitation time for it. Parties cannot sue any time. There is a limitation time period for this. Yes. What is the limitation time period? 3 years. You know that as per Limitation Act, 3 years over, everything over. Right? Yes. So let's say for example, here there was a contract which was barred. Means contract is over because 3 years over. Everything over. If party wants to take action, he can take action only within a period of 3 years. Because once 3 years over, everything over. So this contract is already barred by limitation rule. Time is over here. So now you cannot do anything, right? Yes. So here, 3 years over, everything over. Everything was over. Everything was finished. Okay. Now friends, in this case, if 3 years over, everything over, if this is the case, now after the contract is over by limitation rule, now if any of the parties make some promise to each other, even if, see now obviously there was no need to make this promise because contract is already over by limitation rule. Okay, you refer my example in your lectures if you want to get the detailed example for this. But I hope this is also very clear that if A makes a promise now, even after the contract is barred by limitation, if A is making a promise now, this promise is a valid contract. No one told him to make this promise. It was okay if he doesn't make the promise. But if he makes a promise to pay for a debt which was already barred by limitation, this promise will become a valid contract. That becomes an exception. Only one requirement here, that promise must be in writing. Okay? And wherever I am writing that it has to be in writing, it has to be in writing, it does not mean that every written agreement is a valid contract. It is not that. Every written promise is not a valid contract. Like for example, if I make a written promise, I will kill Chirag. I will kill Chirag. If I make a written promise, I will kill Chirag. So this written promise is a valid contract? No. So writing requirement is necessary only where it is mentioned, not everywhere. Okay. Then we have contract of agency. You know what is agency? Relation between principal and agent. Right. So this agreement is not having any consideration, but still it is a valid contract. Then gifts. You know, whenever one party promises to give some gift, like if I transfer my property to you in the form of gift. So you know, gifts are always free. Gifts are always without any consideration. So if I transfer my property to you, I am transferring the property in your name. What am I getting in return? I'm not getting anything because it's a gift. So tell me, if I'm not getting anything in return here, is this a valid transfer? Is this a valid contract? Yes, because it's a gift. Okay, so gift is also an exception. Then bailment. Yes, you know what is bailment? Bailment means transfer of property from one party to another party. Not because party is selling the property, but it is transfer of property from one party to another party only for a particular purpose. Only for a particular purpose. So when one party is transferring the property to another party only for a particular purpose, as soon as the purpose is over, that party have to return back the property to the owner. Such an arrangement is called as bailment. Such an agreement is called as bailment. Example, when we give you a mobile phone for repair. So you are giving your mobile phone to the repair shop. Are you selling the phone? No. Are you gifting your phone? No. You are giving this mobile phone only for repair purpose. That is only for particular purpose. As soon as the purpose is over, that person will return back the property to you. This arrangement is called as bailment. Right? You give your clothes for ironing, dry cleaning purpose. Bailment. But you know something? Bailment can be gratuitous also and non-gratuitous also. Gratuitous means free. Free means without any consideration. Without any consideration, yes. It can be gratuitous, free. Okay, and it can be non-gratuitous also, means not free, means with consideration. Like for example, if you give your book to your friend, so you're transferring your property from one person to another person for a particular purpose. What was the purpose? Reading purpose. As soon as the reading job is done, that person will return back the property to you. Yes or no? So it is called as what? Whenever return job is done, or whenever the reading job is done, that person will return back the property to you. It is called what? Bailment, without any consideration. Right? You're not going to charge anything from your friend. So bailment can be with consideration also, without consideration also. So that is the point here. So yes, as you know, bailment can be without consideration also. So here we are talking about exceptions where there is no consideration but still it is a valid contract. So as you have seen here, bailment can be without consideration but still valid. Therefore it is a valid contract of bailment. Then last is charity. Come on, when you give something for charity, obviously you don't expect anything in return. Like for example, if I want to give 1 lakh rupees to a temple trust for the repairs of temple. Okay, so I'm giving it in the form of charity obviously. So if I'm making a charity, I'm giving 1 lakh rupees to the trust of temple for repairs of temple. Tell me what is consideration for me? Nothing. I'm not getting anything in return. It's a charity. What is consideration for temple? Temple is getting 1 lakh rupees, money. Yes or no? Yes. Now friends, tell me, if I'm not getting anything in return, I'm person who is making a charity, right? So tell me, is this charity promise? I promise temple that I will give you 1 lakh rupees for the repairs of temple in a week. So whatever promise I have made, is this a valid contract? So friends, you know what happened? As soon as I made a promise, so as per general rule, no consideration, no contract, right? But you know what happened here? I promised to make the payment of 1 lakh rupees. I promised to make a payment of 1 lakh rupees to temple in a week. As soon as I made the promise, temple started the repair work. Temple started the repair work, and now if I don't make the payment, can temple sue me? Yes, temple can sue me because they started the repair work depending on my promise. Now if I don't pay the money, can I say temple will suffer loss? Yes. Are you getting the point? So see, nobody should suffer any loss because of your promise. So the charity becomes a valid promise, valid contract. Even if it's a charity, it becomes a valid contract because repair work was already started. Because now if you don't perform, the opposite party will suffer loss. What if repair work was not started? If repair work was not started, then it is not a valid contract. Because no consideration, no contract. So charity becomes an exception only if the party is suffering some loss because of your promise. Then it becomes an exception. Okay, so these are 7 points of no consideration, no contract. Okay, and then now the last topic is left to finish this unit is Doctrine of Privity. What is the Doctrine of Privity rule says? You know friends, Doctrine of Privity says that the two parties who enters into a contract, the two parties who enter into a contract can sue each other. The two parties who enter into a contract can sue each other. The stranger cannot sue. Only the two parties who enter into a contract can sue each other. Only two parties can sue each other. Stranger to contract cannot sue. Third party cannot sue. Only contracting parties can sue each other. Third party cannot sue. That is the general rule here, that is about Doctrine of Privity. As per general rule, only contracting party can sue each other. Stranger to contract cannot sue. That is the basic rule. But again, there are a few exceptions. Here there are 7 exceptions again. Okay, so I hope you know the basic rule, everyone. Now the contracting party can sue each other, stranger to contract cannot sue. But again, in exception, obviously what is going to happen? In exceptions, you are going to see the circumstances where party is a stranger to contract, but still party can sue. But you know what is the common between all these points? All are beneficiaries. All are beneficiaries. The parties, just imagine you are not a part of contract, you are a stranger to contract, but still you have right to sue when that is possible. Obviously when your right is getting affected. Obviously when you are a beneficiary. Yes or no? So when you are a beneficiary, you can sue. So here are the few circumstances you can see. One is beneficiary in case of trust. Then return family settlement. Like, see, if there is a family agreement, if there is a return family agreement, in that agreement, who is a contracting party? The family members are a contracting party, the two parties who are entering into a contract. Let's say, for example, agreement between two brothers. So they have made a return family settlement agreement, for which they were going to give some amount to mother. Okay. Now agreement is between these two parties. Now if anything goes wrong in this agreement, who can sue each other? These two parties can sue each other? Yes. But even mother can sue them. Why? Tell me, is mother a contracting party? No. Mother is a stranger to contract? Yes. Still mother can sue. Why mother can sue? Mother can sue because she was a beneficiary. She was going to get some amount because of the performance of this contract. So therefore this becomes an exception. Therefore any family member who is a beneficiary can also sue. Okay. Then it is partition of HUF, but friends, this is no more an exception now. Please, you can cancel this point. Now this is not an exception. Earlier it was an exception. Because you know there are changes in HUF laws. So according to those changes now, partition of HUF is not an exception of doctrine of privity. Okay, next is assignment of contract. Here we talk about power of attorney. Yes, here we talk about power of attorney, and we don't talk about beneficiary here. Example, see, if I have a property in Mumbai, and if I want to sell this property to you, okay, so I sold this property to you, we both entered into a contract with each other. What is my duty? My duty is to give you the property. What is your duty? Your duty is to make the payment. What I did, I gave my property, but you are not making the payment. You have done the breach. You are not performing your obligation. Tell me, can I sue you? I am a contracting party? Yes. Are you a contracting party? Yes. If anything goes wrong in this agreement, can we sue each other? Yes. So here, who did wrong? You did wrong. You're not making the payment. Can I sue you? Yes. I am a contracting party. I can sue you. But I am busy with something. I am outside India. I don't have time to file this case. So can I give power of attorney to one of my friend in Mumbai? So answer is yes. I can give power of attorney to one of my friend in Mumbai. What I did is I assigned my rights to one of my friends. That assignment of right is nothing but giving power of attorney. So I assign my rights to him. Now tell me, can he sue you? Yes. Is he a contracting party? No. He's not a contracting party, but still he has right to sue. He is a stranger to contract. Still he has right to sue because of power of attorney, because of assignment of contract. I have assigned my rights to him. Okay, tell me one thing. Is he a beneficiary? Is he a beneficiary? No, he's not a beneficiary. Is he going to get anything? No, he's not going to get anything. Still he has right to sue? Yes, because of power of attorney. So this is the only point where party is not a beneficiary. Okay. I hope this is clear to everyone. So that is assignment of contract. Next is acknowledgement of debt. Here also same beneficiary. Then here we talk about covenant in case of land. Firstly, what do you mean by covenant? Covenant means condition. Covenant means condition. Okay, come on, let's go with the example. Let's say, for example, if I have a plot, if I have a plot and I want to give this plot on lease. I hope you understand lease. Lease means rent for a longer duration. Okay, so if I want to give this plot on lease, but I have a covenant. Covenant means I have a condition that you have to use this plot only for charity purpose. If you use it for charity purpose, I will give it to you. Otherwise, I won't give. So what you did, you agreed to my condition. You agreed to my condition. I gave you the plot. What you did, you constructed a hospital on this plot for charity, obviously for free. So tell me, are you using the plot as per the condition? Yes. No problem, everything is fine. But later on, the owner of plot died. The owner of plot died. Now you are like, now who is watching me? I can do anything with the plot. So now what you did? You destroyed that hospital building and now you constructed a shopping mall. Tell me now, are you doing the breach of condition? Yes. Are you following the condition now? No, you are not following the condition now. So now tell me, if I was alive and if you do this, can I sue you? Yes. Contracting party can sue each other. If I was alive, I would have filed a suit on you. But I am not alive. So now tell me, my family members, my legal representatives, are those legal representatives contracting party? No, they are not contracting party. They are stranger to contract? Yes. Tell me, still, can they sue you? Can they sue you? Answer is yes. Even if they are not a contracting party, they can sue. Are you getting the point, everyone? They can sue. Any doubt in this? So this becomes an exception. So if there is any condition, covenant in case of land, if there is covenant means condition in case of land, and if the owner dies, so in that case legal representative, even if they are not a contracting party, they can sue. So therefore it becomes an exception. Okay, yes, and lastly, last point is contracts made by an agent. You know everyone who is an agent, friends? Agent. Agent means person who acts on behalf of another. Yes or no? Contracts, yes, a person who acts on behalf of another is called as an agent. So if there is a business where one person is the owner of business, another is an agent. If agent is entering into a contract with third party, means with the customer. Okay. If agent does any deal, if does a contract with the third party, if anything goes wrong with the contract, can agent sue third party? Yes, because these both parties are contracting parties. They both can sue each other. Yes or no? But tell me, is principal a contracting party? No, principal is not a contracting party. Principal is stranger to contract. Principal is stranger to contract. So, can principal sue third party? Can principal sue third party? Answer is yes. This is called contract made by an agent. So if contract is entered by an agent, can agent sue? Yes. But even principal can sue. Because act done by an agent is equals to act done by the principal. Whatever act is done by an agent is equals to act done by the principal. I hope this is clear to everyone. So if agent is doing a contract, agent can sue? Yes, but even principal can sue. So that is an exception, contract made by an agent. So these are the 7 exceptions. I hope everything is clear with this. And with this we are finished with your unit number 2. And now we will start with unit number 3. Okay, everyone, unit 2. I hope 2 units are clear to everyone. If you have understood everything, just give a like, please. Just give a like. right? You can just do that so that I can understand, yes, you are getting everything. Okay, and also you should refer all the examples which I have discussed in class. In class I have explained you each and every point with examples, detailed examples, right? I hope you remember everything. Okay friends, so yes, so now what we are going to do is we have done with the 2 units. Now I am going to give you a break of 15 minutes. Break of only 15 minutes. So you just take a break of 15 minutes. After 15 minutes break, again we are going to continue with Indian Contract Act next 2 units. Okay, so after that again I'll give you 15 minutes break. So that way we will be following the breaks. Okay everybody, I hope this is fine, this looks good. So you will get a change, right? So yes, so it's 2/7. Okay, it's 2/10 discount. So we will be back by 2:25. So see you at 2:25. Stay tuned, stay connected. See you after 15 minutes. Thank you so much everybody. See you soon. रेडी एवरीवन?
कंजम्पशन करना है एवरी से 20 इयर्स खत्म होने के बाद 20 मतलब जब 30 इयर्स तो हो चुका होगा, 90% रिपेमेंट हो चुका होगा ये मैक्स। ओके अब तो अगर मैं प्रेफरेंस ठीक है, सो व्हेनेवर नहीं भरोगे तो पेड अप कैपिटल रिडीम हो जाना।
हेलो 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 चलो लेट्स स्टार्ट नाउ। बच्चा लोग यूनिट नंबर 3, यस, यूनिट नंबर 3 के अंदर क्या क्या टॉपिक्स हैं? इसके अंदर देर आर 4 टॉपिक्स। ठीक है, सबसे पहला जो टॉपिक है दैट इज कैपेसिटी ऑफ पार्टीज। यस, अभी आपको पता है बच्चा लोग, अपन ने जो आगे पढ़ा था उसमें अपन ने क्या देखा था? कंसिडरेशन देखा हमने, ऑफर एक्सेप्टेंस देखा और टाइप्स ऑफ कॉन्ट्रैक्ट देखा, असेंशियल एलिमेंट्स देखा, राइट? वैसे ही कैपेसिटी ऑफ पार्टीज, आपको याद है एसेंशियल एलिमेंट्स फॉर अ वैलिड कॉन्ट्रैक्ट में, एसेंशियल एलिमेंट्स फॉर अ वैलिड कॉन्ट्रैक्ट में एक लाइन था कि पार्टीज मस्ट बी competent टू कॉन्ट्रैक्ट इज एन एसेंशियल एलिमेंट फॉर अ वैलिड कॉन्ट्रैक्ट. याद है आपको? पार्टीज मस्ट बी competent टू कॉन्ट्रैक्ट इज एन एसेंशियल एलिमेंट फॉर अ वैलिड कॉन्ट्रैक्ट. मतलब दो लोग जो कॉन्ट्रैक्ट करते हैं ना, वो लोग लीगली competent होने चाहिए कॉन्ट्रैक्ट करने के लिए. मतलब वो लोग लीगली एलिजिबल होने चाहिए कॉन्ट्रैक्ट करने के लिए. मतलब बेसिकली आपको राइट पर्सन के साथ क्या करना है, कॉन्ट्रैक्ट करना है. ठीक है. सो यस, आप सबको समझ आया? पार्टीज मस्ट बी competent टू कॉन्ट्रैक्ट, competency of parties. ठीक है. चलो, तो who all are the parties who are not competent to contract? तो following are the parties who are not competent to contract. Okay, so who are the parties? First one is minor. क्या लगता है, माइनर कॉन्ट्रैक्ट कर सकता है? नहीं कर सकता है. ठीक है. माइनर कौन है पता है ना सबको? हु इज बिलो द एज ऑफ 18 ईयर्स. अगर आपने माइनर के साथ एग्रीमेंट किया भी तो क्या वो वैलिड बनेगा? नहीं. इट इज वॉइड एब इनिशियो. आपको पता है ना वॉइड एब इनिशियो का मतलब क्या होता है? एब्सोल्युटली वॉइड, मतलब वॉइड फ्रॉम द बिगिनिंग. मतलब ये क्या होगा, वॉइड एग्रीमेंट होगा कि वॉइड कॉन्ट्रैक्ट होगा? ये वॉइड एग्रीमेंट होगा. आपको याद है ना टाइप्स ऑफ कॉन्ट्रैक्ट में अपन ने दो देखा था, एक तो वॉइड कॉन्ट्रैक्ट और दूसरा वॉइड एग्रीमेंट. सो दिस वन इज वॉइड एग्रीमेंट. सारे वॉइड एब इनिशियो जो होते हैं वॉइड एग्रीमेंट होता है. ठीक है. इसका फेमस केस लॉ है मोहिरी पीपी वर्सेस धर्मोदास घोष. ठीक है. जहाँ पे वही था कि माइनर ने अपना प्रॉपर्टी वहाँ पे मॉर्गेज किया था, तो मॉर्गेज का जो डीड है दैट इज वॉइड एब इनिशियो. ठीक है. चलो, तो फर्स्ट पार्टी इज माइनर. अभी माइनर रिलेटेड जो है वो सारे यहाँ पे रूल्स है. तो माइनर के साथ एग्रीमेंट करने का, नहीं करने का? नहीं करने का, राइट? यस, यू कैन सी हियर द फर्स्ट पार्टी इज माइनर. So you cannot enter into an agreement with minor. If you enter into an agreement with minor, that agreement is void ab initio. Okay, yes, famous case law, and there are other rules also. Tell me, whatever agreements are done by the minor, will parents be liable for such agreements? Answer is no. Parents of minor are not liable for the action by the minor. Yes, minor's contract do not impose any liability on parents or guardian. Okay. Yes. Then tell me, can parents of minor enter into a contract on behalf of minor? Parents of minor can enter into a contract on behalf of minor. So answer is yes. Yes, parents can enter into a contract on behalf of minor, and such contracts are absolutely valid. Okay, I hope this is clear to everybody. Parents of minor can enter into a contract on behalf of minor. Then parents can enter into a contract on behalf of minor. Such contracts are valid, but there is one type of contract which parents cannot do on behalf of minor. Which are those contracts? Those contracts are regarding purchase of immovable properties. Immovable properties. Yes, parents cannot bind a minor for a contract which is done for purchase of immovable properties. Then friends, what if there is a contract in which minor is a beneficiary? Means you have entered into a contract with a minor. So we say that agreement with minor is void ab initio, right? But if there is a contract with minor in which minor is a beneficiary, means minor is going to get some benefit which is not getting. So can minor sue? Yes, minor can sue because minor can be a beneficiary. Contract in which minor is a beneficiary is a valid contract. Okay. Then minor can always plead minority. You know, even if minor does any fraud in an agreement, if minor gives a false explanation, false information, in all these way, minor is always in the, you know, the decisions are always in the favor of minor because minor can always plead minority. Minor can always take the advantage of minority. Okay, yes. So basically minor is never ever liable for any type of act. Okay. Yes, any doubt in this? Minor can always plead minority. Then friends, what if we enter into an agreement in minority? Okay, if I am 17 years old, I enter into an agreement with a major today. Today I'm 17 years old, and if I enter into an agreement with some major today, when I'm 17 years old, okay. So if I enter into an agreement today when I am a minor, and tomorrow is my birthday, tomorrow I am going to become major. Okay. So if tomorrow I am going to turn major, so tell me, whatever agreements I have done today can be ratified tomorrow? Means can be ratified in future? Answer is no. You know what? Agreements entered in minority cannot be ratified in majority. I am not saying rectify. Rectify means to correct. I am saying ratify. Ratify means to approve. So whatever agreement you do in minority cannot be approved in majority. Why? Because always you have to see what is your competency at the time when you are entering into a contract. At the time of contract you were minor. You were 17 years old. So it cannot be ratified in future. Because it is void ab initio. It is void from the beginning. Right? So ratification of agreement is not allowed. Okay, next. Then minor is never ever liable, minor is never ever liable, we say that. Tell me, can minor become a partner in partnership firm? Can minor become an agent of principal? So answer is yes, minor can become an agent, minor can become a partner also in partnership firm, but can you see this, can be admitted to the benefits of partnership. So he can become partner in partnership firm, he can become agent also, but only for profits. That is only for benefits. He shall not be liable for any act done as an agent. So only for profits he can become agent also, and he can become partner also. Okay. So generally we say in this topic minor is never ever liable, minor is never ever liable, but minor's property is liable for the payment of necessaries. Necessaries means what? In necessaries there are how many things? Five things. Five things are covered in necessaries. That is food, clothing, shelter, health, education. Okay. So if any person spent any amount for the necessaries of minor, if any person spends on food, clothing, shelter, health and education for a minor, okay, now tell me, in that case, can you recover that amount spent from minor? Can you recover that amount spent from minor? The answer is no, you cannot recover that amount spent from minor, but you can recover that amount from minor's property, yes. So therefore we say that minor's property is liable, but minor's property is liable only and only for the payment of necessaries and not for any other things. Okay, so these were the rules of minor, and minor was the first party who cannot enter into a contract, not competent to contract. Come on, who is the second one? Second one is person of unsound mind. What is person of unsound mind? You all know that person who suffers insanity. Person who suffers insanity is called as person of unsound mind, right? So what do you think? Person who is of unsound mind, person who is insane, can you enter into a contract with him? No. If you still enter into a contract with such a person, will contract be valid? No. Contract will be void because this person is not competent to contract. So one was minor, second one is person of unsound mind. What if person is drunk? I'm talking about drunkards. So if a person is drunk, can you enter into a contract with a drunkard? So friends, answer is no. Because drunkard is also considered as person of unsound mind. Drunkard is also considered as person of unsound mind. Okay, so therefore if you do contract with him, it is void obviously. Now one more thing, what if a person is a person who is sometimes of sound mind and sometimes of unsound mind? Sometimes he is of sound mind, sometimes he is of unsound mind. Come on, if you enter into a contract with such a person, then what will happen? Sometimes he is of sound mind, sometimes he is of unsound mind. If you enter into a contract with such a person, what will happen? Will this contract be valid or void? So friends, it depends. At the time of entering into a contract, if this person was of sound mind, then this contract will be absolutely valid. Okay? Or if at the time of contract, if the person is of unsound mind, then contract will be void. So basically you understood at the time of entering into a contract, what is the status that you need to see, that you need to check. Okay, so at the time of contract, if party is of sound mind, contract is absolutely valid. Okay, so this is the point here, person of unsound mind. Easy everybody? Yes, first is minor, second is person of unsound mind. Third one is person disqualified by law. Friends, you know, persons disqualified by law. There are few parties, there are few persons who are disqualified by law. Yes, there are 5 persons who are declared that these people cannot enter into a contract. Who are those 5 people who are disqualified by law to enter into a contract? So, first one is alien enemies. I hope you know who is alien enemy. Alien enemy is a person who belongs to a country against whom official war is going on with India. So all the people of that country will be treated as alien enemy for us. So obviously you cannot enter into a contract with any person who belongs to that country, because all those are our alien enemies. So alien enemy is one of the person who is disqualified by law. Can you enter into a contract with alien friend? So answer is yes. You can enter into a contract with alien friend, because alien friend is a person who belongs to a country against whom official war is not declared with India. Okay, so alien friend, no problem. Alien enemy, big problem. If you enter into a contract with alien friend, contract is valid. If you enter into a contract with alien enemy, contract is void. Okay, tell me, do we have any alien friend right now, or alien enemy right now? Tell me alien enemy right now. Do we have any alien enemy right now? Answer is no. Because is war going on right now with India? No. So all are our alien friends right now. Because here we are talking about official declaration of war, official announcement of war. Okay. So alien enemy is disqualified, alien friend is not disqualified. One more thing, let's say for example if we enter into a contract with alien enemy, okay, and now let's say war is over. Now once the war is over, now can we enter into a contract with people of that country? Or we cannot do that. Now can we enter into a contract with people of that country, or we cannot do that? So answer is yes, now you can enter into a contract. Why? Because once the war is over, now those people belong to your, like, to the category of alien friend. So the point is, conclusion is, alien enemy is disqualified by law to enter into a contract, but this disqualification is only for the duration of war. Once the war is over, again they become eligible. Okay, so this is the first person, remember, who is disqualified by law. Second is insolvents. You know very well, the person who is declared as insolvent by the order of court. So person who is declared as insolvent by the order of court is disqualified by law to enter into a contract. Such person is not allowed to enter into a contract. If you still do contract with such a person, obviously contract shall be void. Contract shall be absolutely void. Okay, next is convict. You know who is a convict, friends? Convict means a person who has been sentenced to imprisonment. Person who is sentenced to imprisonment. Yes, who has been proved guilty. I am not talking about suspects. I am talking about a person who has been proved guilty, who has been sentenced to imprisonment, is called as convict. So obviously this person is also disqualified by law to enter into a contract. If you do contract with such a person, obviously contract shall be void. Okay. One more thing. What if a person has been sentenced to imprisonment for, let's say, 5 years? Okay, person has been sentenced to imprisonment for 5 years. Now once he is out of imprisonment, now tell me, can you enter into a contract with him? Yes, because now he is no more a convict. Now he's just like other citizens. Therefore, can I say that convicts are disqualified by law to enter into a contract, but this disqualification is only for the duration of imprisonment. Once the imprisonment duration is over, again this person is eligible. Okay, so I hope this is clear to everyone. Next is corporation and company. Oh, surprising. Corporation and company. Company cannot enter into a contract. What is this? Sir, we have studied. Company can enter into a contract by its own name. Company is a separate legal entity, artificial person created by law. Company can do contract. Company can do contract. Yes or no? You have this in your mind. But friends, I hope you know every company have their memorandum of association, which is the constitution document of company, which is the supreme document of company. And in MOA you can see the object of company, purpose for which the company is incorporated. Like I took example in class, Ashirvad Atta. Ashirvad Atta, yes. Now see friends, if the object of company Ashirvad Atta Private Limited, for example, if that is the company, actual name is ITC, but for example, if it is Ashirvad Atta Private Limited, tell me what is the purpose of that company? To sell atta, right? So what will be the object of that company? Object of the company will be make atta, sell atta, and make profit, right? Make atta, sell atta, and make profits. So this is the purpose of this company: make atta, sell atta, make profits. Okay. Now friends, if this company enter into a contract related to these activities, related to making atta, selling atta, right? So it's not a problem. But if company enters into a contract something which is beyond its MOA, then there is a big problem. Yes. Basically, my point is company can enter into a contract by its own name, but those contracts must be intra-virus to MOA. What is intra-virus to MOA? Intra-virus means within the object of company, within the MOA of company, as per the object of company. Yes. So if company is entering into a contract as per MOA, in that case such contracts are absolutely valid and company can enter into a contract. But if company enters into a contract beyond its object, means object says that make atta, sell atta, and you are doing contract related to selling cars. So tell me, selling cars is a part of object clause? No. So you are doing contract which is beyond the object, that is ultra virus to MOA. Such contracts are absolutely void. For such contracts, company is disqualified by law to enter into a contract, right? Therefore, tell me, am I saying that company cannot do contracts? No, company can enter into a contracts, but company can enter into a contracts only which is intra-virus to MOA, within the scope of MOA, not beyond the scope of MOA. And if company is doing something which is beyond its object, then company is disqualified by law to enter into such contracts. Are you getting it? Yes. Okay, so company is not completely prohibited to do contracts. Okay, these are the rules for that. Okay, am I saying that company can do only one type of business? It's nothing like that. Company cannot do one type of, is nothing, there are no such restrictions. Company wants to do 10 types of business at the same time, no problem, do 10 types of business, no problem. But you want to sell atta along with cars, no problem. So first what you need to do is, you need to alter your object clause. You need to first go with the alteration of MOA. So first alter your MOA, add car business in it, and then you do contracts of cars. Okay, so that is the rule. Then, yes, so that way it is. Next is foreign sovereign diplomatic staff. Yes. So foreign sovereign diplomatic staff is also a person who is disqualified by law to enter into a contract. You can see here they are saying that foreign sovereign means the person is a foreigner who is under sovereign function and who is also a diplomat. You know, diplomat, VVIP, person who belong to a special category. Let's say for example, if any person who is coming from another country and he's on India visit, and that person belongs to some special category, like he's representing his country basically, like he is some minister, officer, special officer who is on Indian visit. So that type of person is our what? Foreign sovereign diplomatic staff. We cannot enter into a contract with them directly. If you want to do a contract with them, such contracts shall not be enforced in Indian courts without prior approval of central government. Okay, so you need to take the prior approval of central government. Only then Indian courts will consider such cases. So indirectly this point is saying that it is void. Void means not enforceable by Indian law. Simple. Right? So this is the 5 people who are disqualified by law. So to conclude it, come on, who cannot enter into a contract? First one is minor. Second one is person of unsound mind. Right? Third one is person disqualified by law, which contains 5 points: alien enemy, insolvents, convicts, corporation and company, foreign sovereign diplomatic staff. So with this we have completed with our first topic of unit number 3. Now we are going to the second topic of unit number 3, that is free consent. Yes, I hope you remember this. What is this? When we were doing that topic of essential elements of valid contract, do you remember that essential elements of valid contract? In that, even this was one of the essential element. Yes, free consent is an essential element for a valid contract. You know, only consent is not enough. Consent must be free consent. Like for example, if I enter your house, and if I take out some weapon, and if I keep agreement in front of you, and if I ask you to sign the papers, or I'll shoot you. Come on, what will you do? Will you sign or you will not sign? Come on, you will sign or you will not sign? You have to sign. Okay, now tell me, you have signed the agreement, you have given your consent, but tell me, you gave this consent because of the threat? Yes or no? Because of the physical force which I was imposing on you. That was only because of threat. So because of threat you gave your consent, you signed it, you gave your consent, but tell me, did you give your free consent? Did you sign it voluntarily, out of your own will? So answer is no. You signed it, but not out of your own will. Okay, so only consent is not enough. Consent has to be free consent. Means you should enter into a contract without any pressure, right? Without any force. That is what the point is saying. So free consent is an essential element for a valid contract. If you enter into a contract by giving some force, by pressure, so that contract will not be valid, because only consent is not enough. Consent must be free consent. Okay, and here there are a few points related to this. There are 5 points. First one is coercion. What is coercion? Coercion means the example which I took just now. Coercion means to give direct or indirect threat. Direct or indirect threat. Okay, it means physical force is involved, threatening someone. So when one person one person forces another party to enter into a contract by giving threat. Okay, such a circumstances is called as coercion. So what do you think? Coercion agreements are valid or void? Such contracts are valid or void? Such contracts are voidable. Yes. Such contracts are voidable. Means if I give you threat and if I force you to sign the document, sign the agreement, such contracts will be voidable. Voidable means it may be valid, it may be void. Right now that agreement is not valid, not even void. It may be valid, may be void. It is at the option of the suffering party. Yes, voidable means it is at the option of aggrieved party. What is this option of aggrieved party? Means it is at the option of suffering party. Depends on the party. Let's say for example, if I give you threat and I took the property. Okay, you signed the property because of the threat, you signed it. So now the signing that contract is voidable. It may be valid, it may be void. It is at the option of aggrieved party. Matlab it depends on the aggrieved party. Yes. Let's say for example, who is aggrieved party here? You are aggrieved party. You are suffering party, right? Now what if whatever I did later on, if you have no objection with whatever I did, you are still under that threat and you are not raising your objection with whatever happened even after I went off. You are not, you don't have any objection with whatever happened. So if you have no objection, in such case, contract shall be valid. Contract shall be valid. Okay. And if you raise your objection, in such case, whatever signing was done, that will become void. Means that will become not enforceable by law. Are you getting it? Therefore, we say it is at the option of aggrieved party. So first point was coercion. Okay. Second one was undue influence. What is undue influence? See, in coercion, threat was the determining factor. Similarly, in undue influence, moral pressure is determining factor. Here, you will see moral pressure is created. Yes. Can you see this? Mental forces involved. Like in this, you know what it is? One person who is at a position creates the moral pressure on another person. In this case, person is not giving you any threat. He is just at a position and is trying to create mental force on you. He is trying to create moral pressure on you, and you have no option but to listen to him. You have no option but to listen to him. Like, for example, if doctor tells you that if you want to save life of this patient, that car, please transfer that car in my name. What you will do? Patient is serious, and doctor told you that if you want to save life of this patient, transfer that car in my name. What you will do? Will you transfer the car? You have to transfer the car because patient is serious. You know, doctor is at a position. He's creating moral pressure on you, and you have no option but to listen to him. So what you did? You gave your car. Now again, tell me, you gave your car. Did doctor give you any threat? No. He was smiling. But just because of he's at a position, you can't do anything. Right? So this is called undue influence. Doctor can create that moral pressure on a patient. So you have no option but to give the property. So you gave your car. Tell me, did you give your car? Yes. Did you give your consent? Yes. But did you give your free consent? No. So only consent is not enough. Consent must be free consent. Okay? So if free consent is missing, it is not a valid contract. I hope this is clear to everyone. Yes, see here the examples: lawyer, client, doctor, patient, spiritual advisor and devotee, parents, child, teacher, student. Husband, wife is not this example. Husband, wife is not example of undue influence. Yeah, maybe in the real life there are undue influence cases, but as per law, husband and wife both are at the equal position. So therefore, no undue influence. Okay? But come on, now here also you saw the person is creating moral pressure, right? In coercion it was threat, here it is moral pressure. Come on, if there is a contract which you do under undue influence, under this situation, like you gave your car to doctor, tell me, will that transfer of car, will that contract be valid? No, because you have not given your free consent. Will that contract be void? No. Again here it is voidable. Contract will be voidable. What is voidable? It may be valid. It may be void. It is at the option of aggrieved party. Come on, tell me, who is aggrieved party here? Who is aggrieved party here? Who is suffering party here? Here suffering party is patient. So later on, if he raises objection, so whatever signing was done, whatever transfer was, that will be void. And if party is having no objection, if patient says that okay, patient is all right now, we don't want car, let it be. So you have no objection in that case. So if you have no objection, that will be valid. That transfer will be absolutely valid. Okay, so that is undue influence. Okay, what if one day, you know what happened? One day my wife told me that please transfer this property to my brother. Why? transfer this property to my brother, otherwise I will jump from the window. Tell me, what should I do now? Come on, what is this case? Is this undue influence or it is coercion? What do you think? It is undue influence or it is coercion? What do you think? Friends, this is coercion. You know what? This is threat to suicide. You know, threat to suicide is also coercion. Any type of threat is coercion. Okay, done. So here we are done. Yes. So undue influence and coercion. Next, third point is fraud. Yes, fraud is defined as always, it is an intentionally done. Yes, it is not an innocent act. Here, always one party is having intent to deceive the other party. One party is having intention to cheat the other party. Deceive means to cheat. That is called fraud. Okay, it is intentionally done. It is not an innocent act. One party is having intention to cheat the other party always. That is fraud. Okay, can you see this? Few statements are given here. Active concealment of fact by one having knowledge or belief of the fact. Means you know the goods are not in the right condition. But what you are trying to do is active concealment of fact. Means you are trying to hide the fact. So if you are doing it deliberately, it is fraud. Right? A promise is made without any intention to fulfill it. Why are you making a promise when you don't have intention to fulfill it? So if you make a promise without having any intention to fulfill it, it is also fraud. Okay, any other act fitted to deceive means to cheat. All these are the examples basically, right? So like for example, if I sell my car to you, making a false claims like car is the best condition, this, that, right? So tell me, what about that contract? Is that valid or void? Such contracts are absolutely voidable. Again, fraud is also voidable. Okay. Yes. Can you see this effect of fraud is again voidable at the option of party who is aggrieved party, suffering party. Okay. Now tell me, friends, will silence amounts to fraud? Like if you are silent, if you're not giving false explanation, and you are not even giving the right explanation, you are just silent. See, if you give false explanation of something, obviously it is fraud because you have intention to cheat, right? But what if you remain silent? You are not giving any false information. You are trying to disclose the facts. You are just silent. So tell me, in this case, what will happen? Will this type of silence amounts to fraud? Will this types of silence amounts to fraud? So friends, generally silence does not amount to fraud. Generally silence is not fraud, but wherever silence is equivalent to speech, means whenever it is your duty to speak, it is your duty to disclose the facts, and you remain silent, such silence is fraud. Such silence is fraud. So it amounts to fraud. Okay, so that is your fraud. Now next is misrepresentation. Misrepresentation is totally opposite of fraud. Misrepresentation is innocent act. Here party will not have any intention to cheat the other party. Here one party is having no intention to cheat the other party. It is innocently done. Okay, that is misrepresentation. Okay, what if you give a false statement to someone which you believe it to be true? You are making a false statement which you believe it to be true. Tell me what it is. It is fraud or it is misrepresentation? Come on, you are making a false statement, but according to you, that statement is, that information is true. That means, can I say you are making a statement considering it as a true statement? Yes. That means, can I say you are making a statement innocently? Yes. In good faith? Yes. Therefore, it is a case of misrepresentation. Okay, can you see this false statement which is made innocently? It is misrepresentation without any intention to cheat the other party. Okay, yes, but again, in misrepresentation also it is voidable. May be valid, may be void. So friends, these are the four circumstances, that is coercion, undue influence, fraud, misrepresentation. All these four are voidable. Please make a note of this. Okay, and then last point is mistake. Yes, last point is mistake. I hope you know what it is. Mistake, yes, mistake are of two categories. One is mistake of law, another is mistake of fact. In mistake of law, there are two types of law. One is Indian law, another is foreign law. If you do something, if you do an agreement, if you do something which is considered as a mistake in the eyes of Indian law, if you do something which is a mistake in the eyes of Indian law, such an act, whatever you have done, is valid or void. Whatever act you have done is valid or void. Such an act is absolutely valid and it is not excusable. See, I'll explain you this. Firstly, whatever act you have done, that is a mistake in the eyes of Indian law. According to law, Indian law, this is a mistake. So will Indian law excuse you, or Indian law will not excuse you? So obviously Indian law will not excuse you. Therefore, mistake under Indian law is not excusable, and whatever act you have done, that act is treated as a valid act. You know what does a valid act mean here? Valid act means enforceable by law. Means court will enforce this activity. Valid means I'm not saying that that mistake is valid, you can continuously perform it. No. I am talking about those agreements, I'm talking about those acts which you have done, which is a mistake in the eyes of Indian law. So those acts are not excusable and those are absolutely valid. Because Indian law is not excusing you, right? Indian law will punish you, right? So Indian law is interfering, right? Therefore it is valid. But what if you do such an act, if you do something which is a mistake in the eyes of foreign law? If you perform an act which is a mistake under foreign law, whatever act you have done, whatever agreement you have done, this is a mistake in the eyes of foreign law. So for that, will Indian law punish you or excuse you? So obviously whatever act you have done, if that is a mistake in the eyes of foreign law, it is excusable by our law. Excusable means law will not punish you. Law will not interfere. Not interfere means void, not enforceable by law. Right? So this is your mistake of law. Everybody understood this? Next is mistake of fact. Fact means you understand the facts. Actually, what has happened. Now there are two categories here. One is bilateral mistake. Another is unilateral mistake. Bilateral mistake and unilateral mistake. Okay. What is bilateral mistake? Bilateral mistake means both the parties of contracts are under mistake. Means both the parties are not aware about the facts. Both the parties don't know what is the fact, what has actually happened. Both the parties are not aware about it. Okay. So if in a contract both the parties are unaware about the facts, both the parties are under mistake of facts, both the parties, such a contract is absolutely void. And on the other side, unilateral mistake, only one party to contract is under mistake. Only one party is not aware about the fact. In that case, contract is absolutely valid. Okay, so this is a mistake. Mistake of law, mistake of fact. Okay, so with this we are done with free consent topic and we have finished two topics of unit number 3. One is capacity of party and second one is free consent. Now we are going to the third topic, that is unlawful object, unlawful consideration. Do you remember that essential element? The object of agreement must be lawful and lawful consideration. Yes. So here they are saying something. Firstly, you can see there are 6 points in front of you. These 6 points are talking about the meaning of unlawful object, unlawful consideration. Yes, it is talking about the meaning of unlawful object, unlawful consideration. Yes, what is the meaning? Let's see. First, what is unlawful object, unlawful consideration? So it is an agreement forbidden by law. Forbidden means prohibited by law. So if you do an agreement which is forbidden by law, means if you do an agreement which is prohibited by law, so obviously that agreement will be unlawful. Yes or no? If you are doing an agreement which is forbidden by law, means which is not allowed by law, still you do that agreement, so it is called as what? Unlawful object, unlawful consideration. Okay, then next is agreement defeating the provisions of law. Defeating the provisions of law or any rule, right? What is this agreement? You are doing an agreement which is defeating the law. Defeating the law means against the law. If you are doing an agreement which is against the law, so obviously that agreement will be what? Obviously that agreement will be valid or void? Obviously void, because you are doing something which is against the law, right? So agreement which is forbidden by law, agreement which is against the law. Then next is where the object of agreement is unlawful because it involves injury to a person or person's property. Yes, like for example, if you are getting a consideration, you are getting something in return which is creating a damage to someone, such type of consideration is not a valid consideration. If you get something in return, but this something in return is a damage to someone or someone's property, this consideration is unlawful consideration. The 6 points are just the meaning, as I told you, of unlawful object, unlawful consideration. Then 1 to 3. Now remaining 3 points, 4, 5 and 6, we have already done in features of consideration. If you remember, there was one point. Consideration must not be illegal, immoral and opposed to public policy. So similarly you can see here consideration, if consideration is immoral, if consideration is fraudulent, if consideration is against the general public, that is, it is opposed to public policy. So yes, if these are the cases, it is unlawful object, unlawful consideration. And if you remember, in the essential elements we have done that agreement must not be illegal, immoral and opposed to public policy. So if you do any of these agreements will be treated as unlawful object, unlawful consideration. Okay. Now here you can see one term, opposed to public policy, that is against the public interest. You know friends, the against the public interest is the point what you can see here. Here are few examples of this opposed to public policy. Yes, can you see trading with enemy? Firstly, today I told you what is opposed to public policy example. Example is bribe. Example is bribe. Obviously, when you are giving bribe to someone, it is unlawful consideration, it is opposed to public policy. Because if giving bribe is valid, then the people who have money, they can do anything. They can just give bribe and they can get rid of any rule. Right? So therefore, these are the points. So all these are what? All these are the examples of opposed to public policy. Yes. Can you see this? Dealing with alien enemy. Trafficking in public office means giving bribe in public office. Interference in the course of law and justice means giving bribe to justice. Right? Then stifling prosecution, giving bribe to prosecution in the court. Right? That is when the case is going on. So the opposite party, the prosecution, you are giving bribe to them. Like maintenance and champity. I told you any additional fees what you give to a professional will be treated as unlawful object, unlawful consideration, opposed to public policy. Marriage brokerage contracts. Here we talk about dowry. Right? Interest against obligation. That is, again you can see you are giving bribe to a manager, to an officer, just because you want your project to be approved. So earlier that person was doing his duty and he rejected your plan because your plan is not appropriate. Therefore he was doing his duty, he was performing his obligation. But now you gave him something under the table, you gave him some amount under the table. So once you gave him under the table any amount, so that is now what he did, he approved your plan. So now he is just thinking about his own interest against his obligation. That is called interest against obligation. Okay, then any agreement which is creating monopoly. So if the two businesses enter into a joint venture agreement to create a monopoly, and now what they want to do, they want to increase the price of their goods and they want to charge higher prices to public. This is also considered as void. This is absolutely void. Okay, where the purpose is to just increase the prices. Such a thing is called as opposed to public policy, and therefore it is void. Okay, so this was the third topic, unlawful object, unlawful consideration. Next topic you can see is, last topic of this unit is, here it is, agreement expressly declared as void. So friends, as I told you, there are few agreements which are declared as void. Even this statement was given in the essential elements for a valid contract. Yes, if you remember, like if you want to do a valid contract, make sure that you don't do a contract which is already declared as void. You don't enter into an agreement which is declared as void. Because if you do an agreement which is already declared as void, how it will be a valid contract? Right? So there are total 5 agreements which are declared as void. Okay. Yes, come on. So agreements expressly declared as void. So now here is the list in front of you, list of the agreements which are already declared as void, already announced as void. Okay, let's see what it is. First one is agreement in restraint of marriage. What do you mean by restraint? Restraint means to restrict. Okay, yes, so if there is an agreement in restraint of marriage, okay, okay, so there is one doubt. So if two parties enter into a contract of doing joint venture, and now in the market there are no other party for that goods, their intention was not of monopoly, then what will government do? See beta, their intention was not of monopoly, but monopoly happened as there are no other sellers of those goods, correct? And here whatever I spoke just now, that was not for putting restrictions for creation of monopoly. Here we are not saying that don't create monopoly. We are saying that if you create monopoly and increase your fares, increase your prices, right, just to earn more money by creating monopoly, such creation of monopoly agreement, joint venture agreement shall be opposed to public policy. So it's not only about creating monopoly. If that thing is against the public interest, you are doing that to, just charge higher fares from the public, from customers, then it is opposed to public policy. So such agreements of monopoly shall be void. All agreements of monopoly shall not be void. Okay, so it depends on that. Clear, Yuraj? Come on. So we are coming to the next topic now. Agreement declared as void, as we were discussing. So here, agreement in restraint of marriage is the first agreement which are declared as void. What is restraint? Restraint means to restrict. Restraint means to restrict. So if there is an agreement which restraint of marriage, means if there is an agreement between two parties and that agreement is restricting someone from getting married. Yes, if any agreement is restricting someone from marriage, such an agreement is declared as void. Such agreement is not a valid agreement. It is agreement which is declared as void, because no agreement can restrict anyone from getting married. Okay, one thing. Secondly, agreement in restraint of trade. Again, restraint means to restrict. In the first point we were talking about agreement which restricts someone from getting married is void. In the second point we are saying agreement in restraint of trade. Means if there is an agreement which is restricting someone from doing trade, which is restricting someone from doing business, such agreement, restraint of trade, is absolutely void. It is declared as void. Why? Because no agreement can restrict anyone from doing trade. No agreement can stop anyone from doing trade. Such an agreement is declared as void. Because you know everyone has freedom of trade. Everyone has right to do free trade, right? So that is the point. Now what is next? Next is agreement in restraint of legal proceedings. What is this agreement in restraint of legal proceedings? See, this is an agreement which is restricting someone from taking legal action. Yes. If suppose I kill you today, if I murder you today, okay, then your parents will sue me, right? So before your parents sue me, what I did, I went to your parents and I offered them 2 crore rupees. I told them, see, whatever happened, it's over now. Forget everything, okay? But keep this money and don't file any case on me. Don't file any suit on me. I gave this offer to your parents. And you know what your parents told me? Come here, come here. They told, okay. Means they accepted my offer. Offer plus acceptance, there is an agreement. Now tell me what type of agreement I have entered into with your parents. This is an agreement which is stopping someone from legal proceedings, stopping someone from taking legal action. Am I trying to stop your parents from taking legal action? Yes. I am stopping your parents from taking legal action. You know, such type of agreements are declared as void. Such agreements are declared as void. Why? Because law says that no agreement can stop anyone from taking legal action. Okay, next one is agreement, meaning of which is uncertain. Do you remember this was one of the essential elements for a valid contract? Everyone, do you remember that? Agreement must be certain. Because if the agreement is uncertain, it is declared as void. Okay. Everyone, yes. So see, here they are saying that agreement, meaning of which is uncertain, means if there is an agreement between two parties where parties are not clear about their obligation. So if parties are not clear about their obligation, what will happen? How will they perform? So such agreement is declared as void. So it's an agreement in which parties are not clear about their obligation. Such an agreement is declared as void. Okay, that is the fourth point. And the last one is wager agreements. Friends, what is wager agreements? Wager agreements means betting agreements. Yes, betting contracts, betting agreements. So obviously betting agreements are absolutely void, right? They cannot be enforced in India. They are void agreements. They are declared as void. Okay, so this is the point here. But remember one thing: wager agreements are declared as void. You know wager agreement, everyone? Wager agreement means it is a game of chance. You know, chance, like betting. When we do betting, it's by chance. You don't have to use your skill in it. It is a game of chance. You may win, you may lose. So wager agreements are declared as void. Okay, but you know, any agreement which is collateral to wager, any agreement which is collateral to wager. What is collateral to wager? Collateral to wager means related to wager. Any agreement which is connected to wager. Example, if we both enter into a betting agreements, I told you if India wins the match, yes, if India wins the match, I want 10,000 rupees. No, I will pay you 10,000 rupees. If Australia wins the match, then I will win 10,000 rupees. So okay, so I am saying Australia will win, you are saying India will win. There is a betting agreement between us. Now finally what happened? India won the match as always. So now you won the bet. Now I have to give you 10,000 rupees, but I don't have it. Okay, tell me, if I don't have it, can you sue me? Can you sue me? Tell me, go on. Can you sue me? Answer me fast. Can you sue me? Everyone. If I don't pay you 10,000 rupees, can you sue me? So friends, obviously answer is no. Why no? Why you cannot sue me? Because it is a wager agreement, it is a betting agreement, therefore you cannot sue me because it is declared as void. Yes or no? Yes. But friends, see, you are my friend, so I don't have money to pay, but I want to pay you. So what I did, I went to my friend, I told him, can you please give me loan of 10,000 rupees? I want to pay them that betting agreement which I lost. Please give me. So I took loan of 10,000 rupees. So can I say here I have a agreement of loan between me and my friend? Are we entering into a loan agreement with my friend? Yes. So this is an agreement of loan. This is betting agreement. So this is wager agreement. This is declared as void, right? But can I say this loan agreement is agreement which is not wager? Is this wager? No, this is not wager. But can I say this agreement is connected to wager? This agreement is collateral to wager. This agreement is related to wager. Yes, it is related to wager. So wager agreements are declared as void. Collateral to wager are absolutely valid. Which means if I if I don't repay the loan, if I don't repay the loan to that party, can that party sue me? Yes, it is valid. Okay, so wager is void, collateral to wager is valid. Okay, now third is, you tell me, what about illegal agreements? Illegal agreements are valid or void? Illegal agreements are valid or void? Obviously they are void, not enforceable by law. Okay, but what about collateral to illegal? Any agreement which is collateral to illegal. If there is an agreement which is collateral to illegal, means connected to illegal. So you know what? Wager was void, collateral to wager was valid. But illegal is void, but anything which is connected to illegal is also treated as illegal. Means this is also void. Yes, this is also void. Easy, everybody? Good. So friends, with this we are done with unit number 3 also. We are done with unit number 3 here, and now unit number 4 starts. And there is one doubt here, why it is illegal in Mumbai only? See beta, these rules are, there are certain powers with a state government. So state government may put some restrictions in their particular state or region. Okay, so that is the rules which are made by the state government. But what we are doing, that is in general, we are talking about Indian Contract Act. Okay, so that is by the contract. That is the restrictions which are imposed by the state government. Okay, fine. Okay, now let's start with unit number 4. Unit number 4 is talking about performance of contract. Yes, what is performance of contract? So friends, in the beginning you can see here, initially the introduction is given. Now what is this introduction? So there is nothing but meaning of performance of contract. Come on, let us understand. Firstly, what is the first step? First is there is formation of a valid contract between two parties. First step is there is formation of a valid contract between two parties. Once the contract is formed between two parties, there is burden on both the parties. Both the parties are under liability. What type of liability? Do they have to pay some amount? No. They are under liability to perform their respective obligations, to perform their promises, what they have made in the agreement. So both parties are under liability, both parties have to perform their respective obligations, and once the party has performed their obligation, once the parties have performed their obligation, what's next? Nothing. Liability will go. Liability comes to an end because parties have performed what they promised. So now liability comes to an end, and even contract is discharged. Contract comes to an end by performance. Parties have performed. So by performance, contract is over in that case. Contract comes to an end in that case. I hope this is clear to everyone. Okay, yes. So this was the meaning of performance of contract. This is the meaning of performance of contract. After meaning, next we have is contract can be performed by. See, in this unit, you will see all the topics are related to performance. Yes, you will see all the topics are related to performance. If this happens, then what will happen? If that happens, then what will happen? It is related to performance. Okay, so let's see what are the rules. So now the topic is contract can be performed by. So who can perform the contract? What are the possibilities of performing contract? Let's see. So first point is contract can be performed by promisor himself. Contract can be performed by promisor himself. What is this? Promisor means person who makes a promise. So when will promisor himself have to perform and no other person can perform? So very simple, promisor himself will have to perform a contract in which personal skill and talent is required for performance. Whenever in a contract, personal skill and talent is required for performance, no one else can perform, promisor himself have to perform. Yes, that is performance by promisor himself. That is in a contract where what is involved? Personal skill and talent is required for performance. Like for example, all the TV stars sign the movies. To act in a movie, they make a promise. So tell me, can anyone perform on their behalf? Answer is no. No one can perform on their behalf. Because for that performance of contract, personal skill and talent is required for performance. So that is promisor himself. Second point is agent of promisor. You know who is an agent? Agent is a person who acts on behalf of another, right? So agent can perform. Means any other person can perform. How is this possible? When this is possible? So very simple. Whenever in a contract, personal skill and talent is not required for performance. Whenever personal skill and talent is not required for performance, in such case performance can be done by agent also. Like for example, if I am a owner of grocery store. I am a owner of grocery store, you came to my shop, you gave me the list of items, and I, being the owner, I made a promise to you. I made a promise, okay? What promise I made? I made a promise to you that I will deliver you all this list of items. I will deliver you all this list of items tonight 9 p.m. I made this promise. Who is the promiser? I am the promiser. Okay. Now what happened? Today evening 9 p.m. what I did? I asked my employee to deliver at your residence. So he went for delivery. Now he came to your place for delivery. Come on, tell me, is he my agent? Yes. He's acting on my behalf? Yes. So tell me, is this a valid performance? Is this okay for you? Yes, it is okay for you, or it is not okay for you. It is okay for you. So why this is okay for you in this example? Because for this performance, because promise was made by me. Promise was made by me. So promiser himself should perform, right? No. In this example, agent can also perform. Why? Because in this example, personal skill and talent is not required for performance. Here, personal skill and talent is not required for performance. So in such case, even agent can perform. Okay. Then third is representatives. You know, whenever two parties enter into a contract, and if any of the party dies, or if any of the party suffers insanity, if any of the party dies, if any of the party suffers insanity, then after the contract is made, if any of the party, after the contract is made, if any of the party dies or suffers insanity, then legal representative of that party will have to perform. Legal representative of that party will have to perform. Okay, therefore performance by legal representative. That is in case of death and insanity. But friends, what about example of that acting in a movie? Come on, in that movie, if the promiser dies after the contract is made, can legal representative perform the contract? No. So in that case, this point will not be applicable. That is, the circumstances where personal skill and talent is required for performance. So where personal skill and talent is required for performance, and in that case, if it is a case of death and insanity, legal representative cannot perform. So in such case, what will happen? In such case, contract will be discharged. Contract will come to an end. Okay. And last is third person. What is this performance by third person? Friends, whenever in a contract, a performance is done by a person who is not a promiser, who is not a promiser, who is not his agent, who is not even his legal representative, and he's someone else. So if the contract is performed by a person who is other than promiser, agent, representative, other than this three, okay, the person is neither of this, none of them, but person is other than them, so such person is called as third person. So performance is done by third person. In that case, that person is called as third person. Okay, so this is the four possibilities of performance of contract. Contract can be performed by any of them depending on the circumstances. Okay, so I hope this is clear to everybody. Yes. Okay. Now we will. Yes. So now we will come to a doubt. Yes. Here there is a doubt in the chat box. Everybody can read it. Firstly, okay. Yuvraj, you have written something right now. So are you talking about both the things? Both the doubts are connected, or you are talking about something else? Yes, Yuvraj. See, to answer his doubt, everyone concentrate. I am giving you very accurate answer of this doubt. Obviously, whatever I am going to say right now is not there in your syllabus, but I am answering his doubt. Concentrate, everybody. You know there is something called as succession. You know what is succession? There is something called as succession. There is also act on this, Indian Succession Act, if you know. Okay, so his doubt is, parent or a guardian had a debt, okay, or a liability to pay someone. Now they died. So is a minor liable to pay that amount to other party? This is his doubt. Everybody understood? So answer is, see what happens is, I tell you, I'll take one example. Suppose there is one father. And there is his son. Father is having assets also and liabilities also. Okay, like father is having asset of 1 CR and liability of 20 lakhs. Okay, this is the situation. And now what happened? Now father died. Now on death of father, as per succession rules, the assets will be transferred to his son. The benefits will be given to the son. Okay, so son will get assets of 1 CR. Okay, and as per succession rules, on death of father, and you know whatever I'm saying, this the assets will be transferred to son. You know what is this transfer? This transfer is done by operation of law. This is done by operation of law. Okay, means This is by succession rules. This means it is automatically by law. Okay, see, there is something called as nomination. That is different thing. I am talking about by operation of law. Okay, so by operation of law, these assets will be transferred to the son. Means son is going to get the assets of 1 CR. But you know, succession rule says what? Succession rule says that, you know, father was having liability also. So succession rule says that if you get benefit, you will also get burden. If you get assets, you will also get liability. So as assets were transferred to son, even liability will be transferred to son. Yes, liability of 20 lakhs. So yes, he is liable for this liability of 20 lakhs. Okay, any problem in this? No problem. Because his father has given him assets of 1 CR. So out of this 1 CR, he can easily pay this liability. And obviously the creditors, the opposite party, the outsider, have right to demand this liability out of these assets. Okay, this is one scenario. Second scenario, same situation, father, son. Father is having asset also, liability also. Okay, but this time father is having liability of 1 CR and assets of only 20 lakhs. Okay, and same thing happens like if father dies, then what will happen? If father dies in this case, so as per succession, the property goes to son. Correct? The property shall be transferred by operation of law, and son will get the assets of 20 lakhs. But as I told you, son gets benefit, so son will get burden also. So tell me, son has received this property of 20 lakhs. Will son be liable for 1 CR? Will son be liable for 1 CR? How much liability will be transmitted to son in this case? So answer is, friends, under succession, the liability shall be transferred. Son will be liable, but only up to the extent of assets received in succession. You understood? He will be liable only up to the extent of assets received in succession. How much assets he has received in succession here? In second situation, he has received assets of 20 lakhs. Therefore, he will be liable for how much? Only 20 lakhs. Understood? He is not liable to pay anything from his pocket. He will be liable only from the assets what he has received in succession. He would directly tell to this outsiders, to the creditors, if you want more money, please go and talk to my father. Simple. Okay, so I guess this was the perfect example for your doubt, Yuvraj. Have you understood this? Please acknowledge. Everybody understood? Okay, Yuvraj. So Yuvraj, you have understood this out of the box doubt it was, right? But like we are teaching from last so many years now, so 14 years now. So if you have understood this, I just want you to give a like to this video, like or comment whatever you like. Okay, let's go. Come back to exam oriented content again now. Okay, let's go. So now unit 4, contract can be performed by. Let's go. Next topic is effects of refusal of party to perform. What is this topic? Can you see, friends, what is the topic? Topic is effects of refusal of party to perform. Yes. What is this effects of refusal of party to perform? What are the effects if any party in a contract refuses to perform? So very simple. Whenever there is a contract between two parties, A and B, obviously both parties have to perform, right? Now suppose if A had to perform first, okay? If A had to perform first and then B was about to perform, but A refused to perform. So if one party refuses to perform, what will be the effects of this? So if one party refuses to perform, can I say other party will have certain rights? Yes. Other party will have certain rights. Other party will have certain rights. What are the rights of other party? Come on, tell me. If first party refuses to perform, can other party resign the contract? Can other party resign the contract? Resign the contract means cancel the contract. Yes. Other party can resign the contract, cancel the contract. Other party have right to cancel the contract. This is the first effect, okay? Party have right to terminate the contract. Okay? Party have right to terminate the contract. Plus, if A has refused to perform and because of his refusal, there is a chance that B may have suffered some damage. B may have suffered some loss. Can B sue A and demand the damages? Can sue. Can B sue for damages? Can B ask for his loss amount? Yes, no. So friends, answer is yes. This is also the effect. That is, aggrieved party can ask for damages. So first is B have right to cancel the contract. When I say that B have right to cancel the contract means, can I say B is cancelling the contract rightfully? Yes. So he has right to cancel the contract. Cancel the contract means B is now excused from performance. Means like for example, if A does not deliver the goods, B will not make the payment. Simple. So B is excused from performance. Plus B have right to sue for damages. And third, if the parties want, they may also continue the contract. If they want to continue the contract later on, like for example A refused first, later on if A comes and if A says that let's continue the contract, so if both parties agree to that, they can also continue the contract. But obviously whatever the damages party will suffer, the other party have to compensate. So these are the three effects of refusal of party to perform. That's all the topic is all about. This is the example, but I already took example here in front of you. Okay, next is what? Next is reciprocal promises. So reciprocal promise is defined in section 2, subsection F. Okay, you know what a reciprocal promise is? You know, in a contract, there are two parties, right? Now see, in a contract where there are two parties, A and B, there is a contract between them, and you know, in this contract, A made a promise to deliver goods to B. So this is one promise, to deliver goods. Why A made this promise to deliver goods? Because A is getting another promise in return from B. A is getting another promise in return, promise to make the payment. Promise to make the payment, yes. This is second promise. Why A is making a promise to deliver goods? Because A is getting another promise from B to make the payment. Why B is making this promise to make the payment? Why B is making this promise to make the payment? Because B is getting another promise for goods. Can I say in this contract, both the parties are making promises to each other? Yes. A is making a promise because A is getting another promise in return. B is making a promise because B is getting another promise in return. Can I say in a contract there are two promises? Yes. Can I say these two promises are consideration for each other? Yes. I'm not talking about what you are getting in return. I'm talking about the promises. Are these two promises consideration of each other? Yes. You know, these promises are called as reciprocal promises. Reciprocal promises. Now you'll say, sir, every contract have two parties, every contract have two promises. I agree, but those promises were called as reciprocal promises. You were not aware about this. Okay, so please make a note of this. So this was the meaning and definition of reciprocal promises. After that, we have one topic here: effects of preventing the performance of reciprocal promise. What is this effect of preventing the performance of reciprocal promise? Please listen carefully, everyone. Okay? Yes. See, friends, whenever in a contract, there are two parties, as you know. Whenever in a contract, when one party is ready to perform his obligation, when one party is ready to perform his promise, perform his obligation, it is the duty of other party to allow him to perform. When one party is ready to perform his obligation, it is a duty of other party to allow him to perform. That is, it is a duty of other party to provide him the reasonable facility which is required for performance. Yes. To allow him to perform, that is, to provide him reasonable facility which is required for performance. If party is ready to perform, if promisor is ready to perform, and if this party is not providing him the facility which is required for performance, that means, can I say this party is preventing the performance? This party is stopping him to perform. Yes, you are stopping him to perform. So what is the effect of this thing? That is the topic here. What is the effect of preventing the performance? So effect is, if party is ready to perform and if you don't allow him to perform, if you stop his performance, if you prevent his performance by not giving him facility, so what is the effect? There are two effects. First effect is, if you stop him to perform, tell me, it is whose mistake? Promiser mistake, promisee mistake? Promisee mistake, because it is a duty of promisee to provide him the facility which is required for performance. Yes or no? Yes. So in such case, effect is, promisor will now be excused from performance. Promisor will be excused from performance, and that contract will be voidable. These are the two effects of preventing the performance. Remember, this is voidable, and the free consent topic was voidable. You know what is voidable, right? It is at the option of suffering party. Okay, next topic is legal and illegal reciprocal promises. Very simple, friends. You know, legal promises are valid and enforceable by law. Illegal promises are not valid, right? Not enforceable by law. Very simple. Then next topic is impossibility of performance of contract. Impossibility of performance of contract. You know, when we were doing the essential elements for a valid contract in unit number 1, that time we saw this essential, yes, impossibility of performance. There was one point, last point, 10th point, that performance must not be impossible is an essential element for a valid contract. So whatever agreement you do, make sure that you should enter into an agreement performance of which is possible. Because if you do agreements for impossible things, it is absolutely void. Okay, so that is the thing. So you know, there are two types of impossibility. First is impossibility existing at the time of contract. Okay, and second is supervening impossibility. What is this impossibility existing at the time of contract? Means at the time when the offer was made, it is impossible from the beginning. Impossibility exists at the time of contract. Means when you were entering into a contract, at that time itself the performance was impossible. Means it is impossible from the beginning, right? So what do you think? You know, performance must not be impossible. And here, if your performance is impossible from the beginning, that means this is void from the beginning. Means it is void ab initio. Means it is void agreement or void contract. It is obviously void agreement. It is void agreement. Okay? Yes. Now in this case it is impossible from the beginning. You know, even if the parties were aware, both parties who are doing the agreement, even if the parties were aware about the impossibility, parties were not aware about impossibility, doesn't matter, it's void. Okay. But what if the impossibility is known only to the promisor? The person who is making a promise, only he was aware about the impossibility. Promisee was not aware about impossibility. Yes, according to promisee, it is possible. But promisor, person who is making a promise, was aware that this is impossible. So friends, can I say, if promisor was aware about impossibility, promisor should not make a promise. Still, if you make a promise, and if because of your promise, promisee suffers any loss, in such case, promisee have right to sue for damages and recover the loss amount, whatever damage or losses party has faced. Have you understood this? Example like, let's say for example, if we have promised you to provide you offline lectures, face-to-face lectures in strict lockdown. In strict lockdown, we will provide you face-to-face lectures. Okay, if I make this promise, I am aware, promisor is aware that this is impossible. But promisee thought that that might be possible. JK Shah classes, anything can happen. Right? So, promisee was aware about, promisor was aware about impossibility. Promisee, according to promisee, it was possible. So if this happens and if there is any loss to the promisee, so in such case, promisee have right to sue for damages, right to claim compensation for the loss suffered. Okay, done? Yes, the next type of impossibility is supervening impossibility. What is supervening impossibility? See, in the first point I told you, this was a case where it is impossible from the beginning. Like example which I gave you, go and count the number of liters of water in the Arabian Sea. It is what? It is impossible from the beginning. It is void from the beginning. But in supervening impossibility, it is totally opposite. In supervening impossibility, performance of contract was possible initially. Means at the time of contract, performance was possible. Later on, it became impossible. After the contract was formed, it became impossible. Are you getting it? So at the time of contract, earlier it was possible to perform. Later on, performance became impossible. Means in the beginning it was a valid contract. Later on, impossibility arose. Therefore, later on it became void. Therefore, this is called as void contract and not void agreement. Because this is not void ab initio. This is not void ab initio. It is not void from the beginning. Okay. Yes. And here are few circumstances.
ओके, यहाँ पे स्टॉक का मतलब क्या है देख लेते हैं। कल पढ़ा, लास्ट लेक्चर में पढ़ा था। शेयर मीन शेयर इन द शेयर कैपिटल ऑफ द कंपनी।
Hello. Hello, hello, hello. Hello, 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 hello. Hello. Yes, friends. Chalo, we can continue. So last we did was impossibility of performance. Two types of impossibility. One existing at the time of contract and second one was supervening impossibility. Okay? Yes. What is the next one? Next topic is joint promise. Now what is joint promise? बच्चा लोग joint promise, as I told you, आपको पता है promise क्या होता है? Promise means आप सबको पता है promise means promise करना, right? Very simple. लेकिन यहाँ पे जो अपना टॉपिक है वो joint promise का टॉपिक है. मतलब promise किसने किया? एक पर्सन ने नहीं किया. Promise is made by more than one person jointly. So whenever the promise is made by more than one person jointly, it is called as joint promise. क्या बोलते हैं उसको? Joint promise बोलते हैं. When the promise is made by more than one person jointly. तो जब भी joint promise होता है तो promiser कितने लोग हैं? एक है या एक से ज़्यादा है? एक से ज़्यादा है. Okay. So जब promise करने वाला एक से ज़्यादा है तो मुझे बताओ who is liable to perform the promise? All joint promisers are jointly liable to perform the promise. Okay. Yes. इतना ही है simple. फिर there is something called as restoration of benefit under void contract. यहाँ पे एक Latin maxim है quantum meruit, which means as much as is earned. ये क्या है quantum meruit as much as is earned? बच्चा लोग आपको पता है कॉन्ट्रैक्ट के अंदर जब भी हम किसी पार्टी को कुछ एडवांस अमाउंट देते हैं, like when we go for to buy something, when we go to buy something and we pay some advance money. So whenever we make some advance payment to the vendor, and what if that vendor breaks the contract? Can you sue him for the damages? Yes. Plus, can you ask him to return your advance? Yes. So you can see in this contract you have given some benefit to that party. Yes, you have given that advance money to that party. So whenever you give some advance money to the opposite party, in that case, if contract becomes void, if the opposite party breaks the contract, does not perform his obligation, in that case you have right to restore such benefit. You have right to restore such benefit. You have right to take back that benefit, and you can apply to court for quantum meruit. Quantum meruit means as much as is earned. You can demand court for quantum meruit. It means whatever benefit you have passed on, you want it back. So that is also a remedy. What you get, like any benefit what is received, you can take it back. Is returned back under the rule of quantum meruit. Then next is remission. Very simple thing. What is remission? Remission means acceptance of lesser amount in full and final settlement. Acceptance of lesser amount in full and final settlement. Let's say for example, you are liable to pay me 1 lakh rupees. You are liable to pay me 1 lakh rupees. That is a credit sale of goods. Okay. So you are liable to pay me 1 lakh rupees, but that credit sale was 2 months credit. Okay. But now you are going, I have delivered you the goods. So you will make the payment when? After 2 months only. But I am in need of money now. So I have asked you for money. I told you, can you please make the payment today? I needed money urgently. So you told me, no, we have decided to make the payment after 2 months. So I will make the payment after 2 months only, not now. But I told you, please make the payment. I am in need of money. Please, it's urgent. So you are saying, no, I will pay after 2 months only. So what I did now, I made an offer to you. I told you, listen, if you pay me money in 2 days, and then you have to pay only 90,000. Instead of 1 lakh, you have to pay only 90,000. Come on, tell me what I am trying to do. Is this a cash discount? Yes. What you did, you will immediately pay me because you are getting benefit of 10,000. So you paid 90,000 to me. Now you tell me, did I accepted a lesser amount? Yes. In full and final settlement? Yes. So if you pay me 90,000 right now, if I accept 90,000, will I demand the remaining amount from you anymore? No. Because whatever amount I have accepted, 90,000 I have accepted, that is called remission. Acceptance of lesser amount in full and final settlement. And once you make the payment, contract is discharge. Contract comes to an end. Okay, so that is the point. Then the next one is effects of neglect of promisee. Now this is something which you already know. Do you remember that topic in unit number 4 which I told you? That promiser is ready to perform, but promisee is preventing the performance. Promisee is preventing the performance. Promisee is stopping the performance. Promisee is not allowing to perform. That is called neglect of promisee. Then later on I told you the effect of that. What will happen? If promisee is stopping the performance, what will happen? In such case, promisor is excused from performance and contract becomes voidable. So here it is, you can see promisor is excused from performance and contract becomes voidable. Basically it's the same thing what we have done over there. Okay, and with this your unit number 4 is also over. So I hope this is clear to everyone. Now we are starting with unit number 5. I hope you all are connected. There was some technical issue for a few minutes, but then again we are continuing with the chapter. Everyone, are you there? Yes, no. Everyone, are you listening? Yuvraj and others? Okay, let's go. Unit number 5. You know, friends, what is unit 5? Unit number 5 is talking about breach of contract. Firstly, what is breach? Breach means not to perform your promise. Is nothing but the meaning of breach. You know, when there is a formation of a valid contract, both parties are bound to perform their obligations, right? But if any party fails to perform his obligation, then it is called as breach of contract. If any party fails to perform or if any party refuses to perform, it is called as a breach of contract. Okay? Yes. But you know, now there are two types of breach: anticipatory breach and actual breach. There are two types of breach: anticipatory breach and actual breach. What is anticipatory breach of contract? Very simple. Whenever there is a contract is already finalized, party have to perform on, let's say, 10th October. Party have to perform the obligation. On 10th October, party have to perform, okay? But on 8th October, party called you and party told you, we are really sorry, we won't be able to perform our obligation. So tell me, did party refuse to perform? Yes. And in the meaning which what I told you, whenever party refuses to perform or fails to perform, it is called as a breach. So here you saw party refused to perform. So if party refused to perform, is this a breach of contract? Yes. You know, party, you tell me one thing, when did party refuse to perform? On the day of performance or before the day of performance? The day of performance was 10th October, but party refused on 8th October. Yes or no? So if party refuses to perform his obligation before the day of performance, it is called as anticipatory breach. When party refuses to perform his obligation before the day of performance, it is called as anticipatory breach of contract. Now tell me, whenever party refuses to perform before the day of performance, means on 8th October itself party refused. Now okay, now you tell me, can you sue that person? Yes, you can sue that person. Now you tell me, when can you sue? Can you sue on 8th October itself, or you will have to wait for the day of performance? When can you sue? Can you sue on 8th October itself, or you will have to wait for the day of performance? What do you think? So answer is, if you want to sue on 8th October itself, you can sue. If you want to wait, you can wait. But will law stop you from filing a suit on 8th October? No. Basically, if you want to sue, you can sue before the day of performance also. So you can see here, in anticipatory breach, party may bring an immediate action for damages, or party may also wait for the day of performance. It depends on the party. Both options are available for you. But if you want to sue immediately, you can sue immediately also. Okay, this is anticipatory breach. The next is actual breach of contract. Actual breach, very simple. Here, the party refuses to perform on the day of performance. Okay, it means party refused to perform his obligation on 10th October. 10th October was the performance day. So on the day of performance, party refused to perform. Party refused to perform his obligation on 10th October itself. On the day of performance. It is called as actual breach of contract. Okay, this is one thing, because actual breach is divided into two parts. One is on the day of performance, and second is during performance. So I hope you know what is on the day of performance. That is refusal on the day of performance. And another one is during performance. What is this during performance? This means where party performs his obligation but not as promised. Party performed his obligation but not as promised. Party has performed but not as promised. Means performance is not appropriate. So what do you think? Just by performing is enough? No, performance has to be up to the mark. You all have to just appear the exam. No, you have to clear the exam. Yes or no? You have to bring the highest marks across India. Yes or no? As always, yes. So that is the point. So if party performs but not as promised, that is also a breach. That is called actual breach during performance. That is called actual breach during performance. Okay, so these are the two types of breach. Now tell me, whenever there is a breach, what will you do? If the opposite party does breach to you, what will you do? Can you sue that party? Yes, you can sue that party. For what? What do you want? You will sue that party for what? What do you want in return? Obviously you want damages. But damages means, what do you want? Actually, what do you need by filing a suit? What do you want? You need money. So what are damages? Here we are going to understand the term damages. You know what are damages? Damages means monetary compensation. Damages means sue for damage, sue for damage. I want my damages. I want my money. That way. So you want what? Oh, you want monetary compensation. Damages means monetary compensation paid by defaulting party. Who will pay damages? Defaulting party to aggrieved party. That is defaulting party to suffering party. For what? For the loss suffered by him. Okay? For the loss suffered by him due to the default of defaulting party. That is the meaning of damages. Right? Always the guilty party is liable to pay damages to the aggrieved party. Right? Meaning of damages. But then you know there are two categories. One is liquidated damages and penalty. You know we did this in class with the help of an example. I request you, if you go with that example, to understand these topics. Otherwise basic, you know the amount of liquidated damage is fair and reasonable. Penalty amount is not fair and reasonable. Liquidated damages is the amount is based on the actual loss. Penalty amount is not based on actual loss. In liquidated damages, the party have intention only to recover the loss. In penalty, party have intention to punish the party. Right? Yes, so all these points we have discussed with example. You please refer to those examples, those are very interesting. Okay, and after this distinguish, now we have a topic that is discharge of contract. Come on, what do you mean by discharge? So obviously discharge means comes to an end. Comes to an end. Yes. So here we are going to see the circumstances, the points. Circumstances where contract comes to an end. Very simple points. These all are the points which we have already done somewhere. Let's go with the points. First, contract comes to an end. Discharged by performance. What do you think? Do you all agree that contract is discharged? Contract comes to an end by performance. Obviously yes. When both the parties perform their obligation, contract is discharged. Therefore, discharged by performance. Contract comes to an end by performance. Next is discharge by mutual agreement. What is that? When both the parties to contract mutually agree, mutually decide to finish the contract, to cancel the contract. So contract is over. Contract is discharged because of mutual agreement. That is, both the parties have agreed for that. Then next is by impossibility of performance. What do you people think? By impossibility of performance, contract comes to an end? Yes, because you all know impossibility agreements are void. Yes or no? So if you enter into an agreement, performance of which is impossible, so obviously in that case it is never going to be performed. So contract is over there. Next is discharge by lapse of time. What do you think? By time, contract comes to an end? Yes. One of the example is Limitation Act, as you know. You know Limitation Act, everyone? 3 years over, everything over. I told you this in second unit. So once the 3 years over, everything is over. Contract is discharged. And another example is, do you remember if employee joins a company and if he signs a contract with the company and that contract is for 5 years. So once the 5 years are lapsed, contract is over. Right? So that is by lapse of time, time over, contract over. Next is discharge by operation of law. That is automatically by law. Reasons can be death of parties, insanity of parties, parties becoming alien enemy, party becoming insolvent, right? All these are the points. But sir, you told us by death or insanity, legal representative will perform. Yes, but do you remember that example I told one more thing, that if personal skill and talent is required for performance, in that case, legal representative cannot perform and contract comes to an end. That is this point. Okay, the next is discharge by breach of contract. What do you think by breach? Contract comes to an end? Yes, because when there are two parties, if any of the party refuses to perform, if any of the party breaks the contract, so what's next? Contract will be performed or will not be performed? Will not be performed. So if contract will not be performed, so what's next? Nothing. Contract is over. So by breach also, contract comes to an end. Obviously in breach you will sue for damages and everything, but are you going to perform the contract anymore? No. Okay, then point number 7 is talking about remission. Do you know remission? I told you, acceptance of lesser amount in full and final settlement. So remission. And lastly, when promisee neglects or refuses to provide promisor the reasonable facility which is required for performance. Do you remember? I told you promisor is performing his obligation, so it is the duty of promisee to provide the facility. If promisee does not provide the facility, what is next? I told you promisor is excused from performance and contract becomes voidable. Promisor is excused from performance and contract becomes voidable. So by that reason also contract comes to an end. Right? So all these are the 8 reasons by which contract is discharged. Okay. Next is 2 small topics. One is contingent contract and another is Quasi contract. So let's talk first about contingent contract. You know what is contingent contract, everyone? It is a contract performance of which may happen, may not happen. It is a contract performance of which may happen, may not happen. Because performance of parties in this contract depends on something. Performance of party in this contract depends on happening or non-happening of a future uncertain event. Example is insurance. Like for example, if I take fire insurance to cover all my goods which are there in my warehouse. So suppose if I buy fire insurance, there is a contract between insurance company and me. What is my obligation? My obligation is to pay insurance fees, insurance premium I paid. What is the obligation of insurance company? The obligation of insurance company is to perform. But you know, insurance company may perform, may not perform. Means insurance company may give the claim, may not give the claim. Because performance of insurance company depends on something. Depends on future uncertain event. What is that future uncertain event? That is fire. If fire takes place, insurance company will give you the claim. If no fire, no claim. So you saw in this case, the performance of insurance company is totally conditional. It totally depends on happening or non-happening of future uncertain event. Obviously, fire is a future event. Obviously, fire is an uncertain event. Right? Can I say in this case, performance is conditional? Yes, because the insurance company will perform if a fire takes place. If there is no fire, no performance. Right? Understood, everyone? So you know what? Contingent contracts are also called as conditional contracts, because always performance is conditional in this case. And it is not necessary that always examples are insurance only in this case. There are other examples also, like for example, if I promise to supply you food grains from my farm if there is good rainfall this year. If there is good rainfall this year. So what do you think? Will I give you food grains? Is this final that I will give you food grains? No. I may perform, I may not perform. My performance depends on something. Yes, my performance depends on happening or non-happening of a future uncertain event, and that event is rainfall. If there is good rainfall, I will perform. No rainfall, no performance. So that is called as contingent contract. And one last thing about this point is, remember one thing, everyone, that friends, if I say that I will buy your car if your car starts flying. Come on, I will buy your car if your car starts flying. Tell me, I will buy your car, is this clear? No. I may buy, I may not buy. That depends on what? Depends on the event. If your car starts flying, I will buy it. But can I say in this case, our contingent contract depends on an event which is impossible. So if contingent contract depends on an event which is impossible, such contingent contract shall be void. As you know, all impossibility is void. Therefore, contingent contract which depends on impossible event is also void. Okay? Clear? Done. Now, what is next? Next is Quasi contract. Very simple. Yes. Yuvraj, they can ask MCQ from anywhere. You may also see that there are no questions asked from this chapter. You may see majority questions are asked from this chapter only. So in this all professional exams, you can't say anything. Anything happens anytime, you just do everything. That's it. Okay. Chalo. Now Quasi contract. You know what is Quasi contract? It is not a contract. It is like a contract. Here, the contracting parties are not contracting parties. They are like contracting parties. Here, parties have no intention to enter into a contract. But still, lawful obligation is imposed on a person which a person is bound to perform. Yes, here, it is like a contract. Here, the parties are not competent to contract, no problem. No consideration, no problem. There is free consent is not there, no problem. I mean to say is no essential elements are required here to be satisfied. Because it is not a contract, it is like a contract. Right? So, it is resemblance of a contract, yes. Yes, and I gave these examples also about this in class, please refer that. Otherwise, I just tell you the meaning. Yes, there is no offer, no acceptance, no consensus ad idem, no essential elements are required here, no agreement. But still, like a contract, burden is imposed on a person. Now that person have to perform that obligation. Okay, so with this, your unit number 5 is over. Now unit number 6 and 7, then our chapter is over. Okay. Now unit number 6, if we say it's very small unit, there are only 2 topics in this: contract of indemnity and contract of guarantee. What is contract of indemnity? You all know that the meaning of the word indemnity means compensate for loss. You know what contract of indemnity means? It is a contract in which one party promises another party to compensate him for his loss. One party is promising another party that if you suffer any loss, I will compensate you for the loss. Such type of contract is called as contract of indemnity. Yes. Any example for this? Yes, insurance. Let's say for example, if we buy medical insurance. So if we buy medical insurance, there is a contract between us and insurance company. In this, insurance company is making a promise to us that if you suffer any loss, any medical expenditure, I will compensate you for your loss. That is called contract of indemnity. Yes. The person who is making a promise to compensate for loss, that person who is making a promise is called as what? Promisor. Means that person is called as indemnifier. That promisor in this agreement is called as indemnifier. That is a person who makes a promise to compensate for loss. And person to whom the promise is made is called as indemnified or indemnity holder. That is basically promisee. Okay, simple. Yes. Yes. Now friends, let's say for example there was a contract between me and insurance company to compensate me for my loss, right? Now what if there was medical expenditure and insurance company didn't give me any amount? Insurance company refuses to compensate for loss. If insurance company refuses to me to compensate for my loss, can I say insurance company has done the breach? Yes. Now do I have certain rights? Yes, there are rights of indemnity holder. Insurance company is indemnifier. I am indemnity holder. Can I sue insurance company? Yes, I have right to sue for recovery of damages. I have right to sue and recover my loss amount, damages. Now if I sue insurance company, do I have to go with the legal procedure? Yes. So in that case, will I have to spend some amount for legal procedure? Yes. So that is expense for me. So the amount which I should get without any expense, now I am getting it by spending expenses for legal expenditure for this legal procedures. So can I demand my actual loss money plus these expenses? Yes. I have right to recover the cost also. Cost of all the defending the suit and everything. Okay, and also if there is any compromise amount, like if any amount I have to compromise, any loss, that also I can demand here. Okay, so you can see here, these are the rights of indemnity holder. So contract of indemnity is talking only this much, that is the meaning, parties and rights. That's it. It's over then. Then here we start with guarantee contract. Contract of guarantee. Very simple topic, There are three parties in this contract. Always there are two parties in contract, but in contract of guarantee there are three parties. Mr. A, bank, and me. Meet Sachdev. This person went to bank for loan. Now bank was not giving him loan. Bank wants guarantor. So I provided his guarantee. Okay. So he's a debtor. Okay, he's a creditor. Bank is a creditor. And I am guarantor. And guarantor is called as surety. Okay. Now tell me one thing. Here, will there be one contract between these two parties? Yes. This is loan contract, loan agreement. Will there be any contract between me and bank? Yes. This will be contingent contract. You know what is contingent contract, right? Performance may happen, may not happen. Sir, how this is contingent contract? Obviously, see, in this case, I'm a guarantor. Guarantor means what? If A does not repay the loan, I will have to repay the loan. Yes or no? Now understand, if A does not repay the loan, I will have to repay the loan. Now tell me, my performance is clear or not clear? My performance is clear or it's not clear? It is obviously, it is uncertain. I will have to repay the loan only if A fails to repay the loan. That means I may perform, I may not perform. My performance depends on happening or non-happening of a future uncertain event. That depends on A's performance. Therefore, this is contingent contract, right? Okay, will there be any contract between me and Mr. A? Yes, this will be contract of indemnity. Why contract of indemnity? Why contract of indemnity here? Because you know what is indemnity contract? One party promises another party to compensate him for his loss. So if I repay the loan because he has not repaid the loan, if I repay the loan, it's loss for me. Can I demand that money from Mr. A later on? Yes. I am a guarantor, so I paid the money to bank. Bank has got their money. Bank is out of picture now. But what about my loss? I have not taken the loan. I was just a guarantor. So can I demand that recovery of amount from Mr. A? Yes. So Mr. A is indemnifier. He will repay me the loan. He is indemnifier. I am indemnity holder. Okay. Is this clear to everyone? So friends, what is the conclusion here? You are talking about, sir, where is contract of guarantee? So this together called as contract of guarantee. Yes, you know what? In contract of guarantee always there are how many parties? 3 parties. Yes, you can see in front of you there are 3 parties. And between these 3 parties, what type of relation it should be there? So there must be relation of contingent contract. There must be contingent contract plus contract of indemnity. So whenever there are 3 parties and between these 3 parties there is a contract of contingency and contract of indemnity. When these both types of contracts are there, this together called as contract of guarantee. This is called as contract of guarantee. Okay, so yes, this is the point. Now you tell me one last thing. Who here in this picture, in this example, primary liability belongs to whom? Mr. A, MS or bank? Primary liability will be imposed on whom? Come on friends, answer me. Primary liability shall be imposed on which part? So obviously answer is Mr. A, because he has taken the loan, so his liability will be primary and my liability will be secondary. Okay, yes. So friends, with this your contract of guarantee is also over, because you know what, here only meaning is given, meaning. Okay, and this is the example, and then here it's over. You know, distinguish are given for reference because you have MCQs, but then it's over here. But actually contract of guarantee is a very big topic. You will study this in your executive in detail, but right now it's only this much. Okay, and with this we are done with your unit number 6 also. And now we are at the last unit, unit number 7, that is agency. Okay, very small topic, contract of agency. Yes, come on. You know friends, what is agency? Agency means relation between principal and agent. Okay, please concentrate, everyone. See, suppose there is one business owner. Okay, he was a businessman in Mumbai, but his clients used to come all the way from Delhi. His clients used to come all the way from Delhi. So what he decided? He decided to appoint one agent in Delhi. So he appointed one person in Delhi, agent. Agent that is to act on his behalf. Okay? So, will there be agency agreement between them? Yes, there was agency agreement between them. Okay. Now tell me, what is consideration for this agency agreement? Obviously agent will do this work free of cost. No, he will charge commission. Yes. So what is the, see, in this agency agreement all the terms and conditions will be mentioned, right? So what is consideration for this agency agreement? You will say, sir, commission, agent will get commission. Yes or no? No. You know, there is no consideration for this agency agreement. There is no consideration. See, because agent don't get commission for becoming an agent. Agent will not get commission for becoming an agent. This agency agreement, he will not get commission for becoming an agent. He will get commission for selling goods. Means agent will get commission for this contracts, what he will be doing it with the clients. I am talking about agency agreement. The agreement of which agent is doing with the principal. So what is consideration for those agreements? So answer is, there is no consideration for agency agreement. But still it is a valid contract. How? How it is a valid contract? Because, you know, creation of agency was an exception of no consideration, no contract. There was one point, if you remember, this is an exception of no consideration, no contract, therefore it is a valid contract. Okay, everybody understood this? After this, now what agent did? Suppose if agent enters into a contract with third party regarding sale of goods. What is the duty of agent? It is the duty of agent to deliver goods. Agent performed his obligation. What is the duty of client? To make the payment. But client refused to pay. Client did the breach. Now tell me, can agent sue client? Can sue? Yes, because, you know, agent is a contracting party, client is a contracting party can sue each other. Therefore, yes, can sue. But tell me, is principal a contracting party? No, he is not a contracting party. He has not done this contract with client. So who is he? He is a stranger to contract. He is a stranger to contract. Still can sue. Can principal sue? So answer is yes. Sir, but how? Only contracting party can sue each other. He is a stranger. Still he can sue? Yes. Because, you know, there was exception of Doctrine of privity, 7th point, contract made by an agent. So if a contract is done by agent can definitely sue, but even principal can sue. So this is what we have discussed earlier too. Now tell me, can minor become an agent? Can minor become an agent? What do you think? Answer is yes. Minor can become an agent. We have done this in minor topic. Minor can become an agent, but only and only for profits. Yes, only and only for benefits. Yes, I hope you remember this. Okay, only for benefits. If there is loss, you know, minor will plead minority. Then tell me, can minor become a principal? Can minor become a principal? Answer is no. Because as per the rules of agency, principal must be a person who is competent to contract. Must be a person who is competent to contract. So is minor competent to contract? No. Therefore minor cannot become a principal. Okay, you know, with this example what is there in front of you, we have finished the first topic of agency. Yes, we are done with the meaning, what is agency, and then we are also done with essentials of agency. Essentials of agency. You know, agency is based on agreement. See this? Can you see this? Agency is based on agreement. Yes, agreement. Then consideration is not necessary. Yes. Can you see this? Consideration is not necessary. Still it is a valid contract because it is an exception. Same thing is given here. Then here we are talking about capacity to employ agent. Capacity to employ agent. What should be your capacity? What should be your eligibility if you want to employ an agent? If you want to appoint an agent, what should be your capacity? Means we are talking about principle. Come on, have we done principles eligibility? Here it is. Principal must be a person who is competent to contract. Right? Then capacity to be employed as an agent. If you want to be an agent, what should be your capacity? We have done this here. Even minor is okay, but only for profits. Right? So with this example, we are done with all the essentials of agency. And after that, you can see modes of agency. That is, how agency is created. What are the different modes of creating the relation of agency between principal and agent? How the relation of agency is created? There are 4 ways. First is by actual authority. First is by actual authority. It's very simple. When, see, agent is acting on behalf of principal, right? So agent is acting on behalf of principal. Why? Obviously because principal gave him that authority. Yes or no? So if principal gives him that authority, therefore he is doing that. So principal gave him authority to act on his behalf? Yes. So that is called agency is created because of delegation of that authority. So by actual authority, agency is created. Second is agency by ostensible. What is ostensible? By representation, by behavior. Like if suppose if I am not an agent of your business, but still I act like an agent, if I represent myself as an agent, if I tell everyone, yes, this is my business, yes, I am an agent, if you let me know if you have some work here. Yes. So I'm not an agent, but I'm acting like an agent. I'm not an agent, but I am acting like an agent. Now in this case, if the real owner comes to know, because there was no agency, I was just acting like an agent. I'm not an agent, I'm acting like an agent. Now if the business comes to know that I'm acting like an agent, and if business is having no objection with my behavior, with my representation, that means, can I say indirectly business is allowing me to act on his behalf? Yes. That means here now agency will be created. Here agency will be created by ostensible, that is by representation, by behavior. Okay, that is ostensible. And in this you can see by estoppel and by holding out. Both means by representation. The next one is agency by ratification. What is ratification? Ratification means to approve. Okay. Suppose if there was agency between principal and agent, there is already an agency. But principal told agent that if you get a contract up to 5 lakh rupees, if you get a contract up to 5 lakh rupees, so what you should do? You deal, no problem. But if you get a contract beyond 5 lakh rupees, you please don't deal, I will handle it. I will handle it. That is what they told, I will handle it. Okay. Now friends, you tell me one thing, they told I will handle it. In this case, what agent did, agent entered into a contract of 25 lakh rupees deal. Can I say there was agency for 5 lakh rupees? So up to 5 lakh rupees agent can act on behalf of principal. But what agent did? Agent entered into a contract of 25 lakh rupees. Tell me, was agent having authority to do this? No. Agent was not having authority to do this. Have you understood this, what I'm saying? But now, whatever he has done, the contract of 25 lakh rupees, what if principal ratify this deal? Ratify means approve this contract. If principal approves this contract, means can I say principal is indirectly allowing agent to enter into a deal of 25 lakh rupees? Yes. So if principal is allowing him, if principal is ratifying such contract, that means principal is creating agency for 25 lakhs also. So here the agency is created for 25 lakhs now, and that agency is created due to ratification. That is called agency by ratification, that is by approval. Okay. Easy? Yes. And last one is agency by necessity. What is agency by necessity? See, there were two neighbors, Sharmas and Varmas. Sharmas went out, house was locked, Varmas were at home. Now Sharmas has received one notice from government authority that kindly pay your outstanding electricity bill amount. But they were not at home. Government wrote, you have to make the payment outstanding bill amount in 2 days or we will disconnect the service. Okay, but there was no one at home. So who read this notice? Varmas read this notice. Varmas read the notice. You understood? Varma read the notice, and Varma, what Varma will do? Varma called up Sharma to inform Sharma that you have to make the payment in 2 days. If you don't make the payment in 2 days, then electricity will go. Are you getting it? He informed. But when he called up Sharma's, there was no communication. There was no connection. No communication. So now there was no communication. See, if there was communication, Varma would do what Sharma will guide him. But as there was no communication, now Varma don't know what to do. Now the circumstances arise that Varma paid bill on behalf of Sharma. Varma paid the bill on his behalf. Because now, see, as there was no communication, now the necessity arised. Now the circumstances arised that now he had to act on his behalf. Okay, so now tell me, the person who acts on behalf of another is called as what? Person who acts on behalf of another is called as agent. And against whom, on whose behalf you act is called as principal. So here you can see there is creation of agency. But here the agency was created by circumstances. That is by, yes, that is by necessity. And that necessity arised because there was no communication. Okay, so here there is agency by necessity. But make sure that there is no communication, only then this creation is possible, otherwise no. Okay, so that is your last by necessity. So these are the 4 modes of agency. Now after this there are simple topics, right? You can read it, like duties of agent, what are the rights of agent, very small things. And yes, termination of agency, that is by what reasons agency comes to an end. So one is by the act of parties, and next is by operation of law. Act of parties means parties did something due to which agency came to an end. That is, first is by mutual agreement. That is, principal and agent mutually agreed to finish the agency. So agency is over. Secondly, revocation by principal. What is revocation by principal? See, principal gave authority to agent to act on his behalf. What if principal revokes the authority? Principal revokes the authority, principal takes back the power. That means, can I say, principal indirectly removes the agent. So once the principal revokes the power, agency comes to an end, right? And then last point says is renunciation by agent. See, in second point, principal removed agent, but in third point, agent himself resigned from office. Yes, agent himself left the business. That is called renunciation by agent. You saw in all the 3 points, parties did something to finish the agency, right? So you have to learn all the head points here, everyone. This was by the act of parties. Then we have by operation of law, that is automatically by law, agency will come to an end. So what are the reasons for this? Reasons are performance of contract. You know this, the contract is performed. Agency, contract is performed. Purpose is over, agency is over. Then expiry of time. There are chances that agency agreement was made for 5 years, 3 years. So 5 years over, agency over. Death or insanity of any of the parties. Principal or agent, any of the party dies, insanity, agency is over. Insolvency, if principal becomes insolvent, you know, principal must be a person who is competent to contract. So if he becomes insolvent, agency is over. Then destruction of subject matter of contract. Let's say, for example, if I appoint you as my agent, I told you I want to buy that building, please you deal on my behalf because you are property dealer. So I told you, you please deal on my behalf. So now tomorrow you are going to deal on my behalf. Okay. So if tomorrow you are going to deal on my behalf, what happened tonight? That building collapsed. Can I say the subject matter of agency is destroyed? Yes. The building for which we were talking, that building is collapsed. The subject matter is gone. So now agency is also gone automatically. That is by operation of law. Okay, and lastly, when party is becoming alien enemy. Like I have business in Mumbai. I have appointed you as my agent in some other country. Because you are going to deal in that country on my behalf. You are going to do my business on my behalf in that other country. Right? And now what happened? That country and this country are in war. So if the two countries are in war, our agency agreement will be in problem. We both will become alien enemy of each other. Principal and agent will become alien enemy of each other, and your agency will come to an end by operation of law. Right? And all these points you have to learn by heart, friends. Okay? And your chapter is almost over. You have sub-agent and substituted agent. And with this, here you just have your distinguished, which is given for reference, and your chapter is over. From here, the MCQs are starting from our textbook. But I hope this much is clear to everyone. Unit number 7. So today we revised Unit 1 to Unit 7. Okay. Everyone, clear with the entire chapter, Indian Contract Act? You know, I want to tell you something. On this YouTube channel, official JKSECS, you should also refer to our previous CSEET revision of all the subjects. They are very useful. The first revision of CSEET on this YouTube channel you will see is Ramban series. Ramban series you will see, and then you will see Yoddha series 1, 2, 3, 4 and so on. This is the 5th one. So please refer to all the series. Okay? You may find different types of MCQs there. Everyone getting the point? Before your CSET exam, refer to all the revision series. Okay? Otherwise, now for today, your Indian Contract Act is over. Yes, I hope this is clear to everyone. So can we solve few MCQs? Are we ready? I want answers in chat box, everyone. Are we ready? Let's go. So the first one is, yes, here you can see, yes, all the Yoddhas here. Are you ready? Yoddha series. Yes, let's go with the MCQs now. Yoddha series with JK Shah classes along with Meet Sir. Yes, let's go. Yes, we will solve few MCQs because you have other MCQs in previous sessions also, because you have your next lecture also, right? So let's see how much we can solve. Come on, yes, everyone started in chat box. Superb response. Let's go. Which of the following agreements are not contracts? Which one are not contracts? Agreements related to social matters, domestic arrangement between husband wife, both A and B. Answer is obviously both A and B. So first answer is C. Okay, contract, because you know here there are no legal obligation. If there is no legal obligation in agreement, that means agreement is social agreement, and social agreements are never ever enforceable by law. They are also called as domestic nature agreements, right? Come on, next. A contracts with B to construct a building. Okay, you saw A contracts with B and makes a promise to construct a building, okay, for a fixed price, and B supplying the necessary material. B is going to supply the necessary material. Can you see this? Both the parties are making promises to each other. So when the two promises are made in a contract which are consideration to each other are called as reciprocal promises. But you know friends, there are types of reciprocal promises also. It is not there in your syllabus, but in exam they can ask. Yes, they used to ask this, because in your CSEET there is no study material, as you know, there is reference material, so they ask anything. Okay, but yes, we have covered so many things, extra things, but still they can ask anything. So this MCQ is one of it. You know friends, in reciprocal promise there are three types. One of the type is mutual and dependent reciprocal promise. What is mutual and dependent reciprocal promise? Friends, mutual and dependent reciprocal means these are the promises, these are the two, because reciprocal promises means always two promises, right, which are made in consideration with each other. So mutual and dependent reciprocal promise means performance of one promise depends on the performance of another promise. You saw here Mr. B is going to supply material and Mr. A is going to construct the building. Now what if, can I say performance of A depends on performance of B? If B supplies the material, then A will construct the building. Right? So performance of one promise depends on the performance of another promise. If B refused to perform, can I say A is excused to perform? If B refused to perform, A is excused from performance. The promise which is made by A shall be excused, because here performance depends on each other. Therefore it is called as mutual and independent reciprocal promise. Okay, there is another type called as independent also, where performance of one promise does not depend on performance of another promise. Then there is mutual and concurrent, where performance of both the promises are made at the same time. That is possible in case of cash sales. Both the parties perform at the same time. Right? So answer is B. Okay, next. If a new contract is substituted in place of a existing contract, it is called as dash. Come on, third one. What is the answer? If new contract is made substituting the current contract. You know, substitution of contract means what? It means novation. Novation. Okay. Yes. You know, alteration means variation. Rescission means to cancel. Okay. Alteration means to change. Rescission means to resign, means to cancel. Okay. Novation means to substitute. Waiver means to give up. To give up the liability. So answer is substitute. That is option C is the right answer. Come on, fourth one, you all know voidable contract is one which can be enforced at the option of aggrieved party, can be enforced at the option of both the parties, cannot be enforced in the court of law, court prohibits. What is the answer? Obviously, answer is A, at the option of aggrieved party. Right? Come on, fifth one. Dash is only a circulation of offer. It is an attempt to induce the offer and it precedes an offer. Come on, what precedes an offer, friends? What precedes an offer? What is done before an offer? Obviously, it is invitation to offer. You know, I told you, invitation to offer is something which leads to offer. So first step is invitation to offer. Because of it, there is an offer, then acceptance, and then it becomes an agreement. If that agreement is enforceable by law, it will become a contract. Okay, next. When goods are displayed in a show window bearing price tags, it indicates dash. Display of goods with price tag. It is obviously again invitation to offer. Yes, invitation to offer. Then, seventh, there is no binding contract in case of dash, as one's offer cannot construed as acceptance. There is no binding contract in case of dash, as one's offer cannot be construed as acceptance. Friends, today only we have revised this, and I also highlighted this line in the textbook also. Answer is cross offer. You know the cross offer, friends? The two offers which are made at the same time for the same thing. Right? So making cross offer does not mean acceptance. Next, Clark owned a dog named Cookie. One day, during a usual walk, the dog ran away and Clark could not trace it. Clark offered a reward to anyone who found and returned the dog. Who announced the reward? Clark announced a reward. Whoever finds the dog and returned it will get a reward. Okay. Now, Fetch found the dog, returned it to Clark before being aware about the offer made by Clark. Means Fetch found the dog, but he was not aware about the offer. Okay. Few days after the incident, he came to know about the offer and he filed a suit against the Clark so that he can get the reward money. But now Clark refused to pay. Which of the following would be the correct outcome of this case? What do you think? Which one is the correct outcome of this case? Which will not be entitled to reward as this was illegal contract? Which will be entitled to reward to finding a dog because no acceptance is required for Clark's offer? Which will be entitled to reward as it was an open contract for anyone who found the missing dog? Which will not be entitled to reward because acceptance of an offer is in ignorance of offer is no acceptance. So friends, answer is option D. If you remember that point, acceptance must be communicated. Yes, there was a famous case law, Lalman Shukla versus Gauridat, and I told you who can accept the offer? Only the person who is aware about the offer can accept the offer. Therefore, is not eligible to reward money. Come on, next. For acceptance to be considered as valid, it must be dash. Absolute, qualified, absolute and unqualified, conditional. What is the answer? So answer is option C, if you remember. Yes. What do you think? Acceptance must be absolute and unqualified. Yes. Then promise to pay time barred debt must be dash. Promise to pay time barred debt must be dash. Do you remember? Promise to pay for a debt which is barred by limitation. This must be dash. Oral promise, implied promise, written and signed, none of the above. Answer is written and signed. Then exceptions to the rule a stranger to contract cannot sue are dash. Yes, here they are talking about exception to doctrine of privity. Which of the following are exceptions to this rule? What do you think? Answer is obviously all of the above. There were 7 exceptions, all of them were the exceptions. Right? Which of the following statements is not correct? Consideration cannot come from third party. Consideration may be executed or executory. Consideration must be real. Consideration may be past also. Which is not correct? They have asked which is not correct. So friends, first statement is not correct. Because they are saying that consideration cannot come from third party. But we have done in the second feature that consideration may move from promisee or any other person also. Right? So this is incorrect. Therefore A option is right answer. Other all 3 are the features of consideration. Okay. Next, as per Indian Contract Act 1872, promises which form consideration or part of consideration for each other are called as dash. Come on, this question was asked in CSEET November 21 exam. Obviously answer is option A, reciprocal promises. They have given meaning of reciprocal promises there. Right? Then, Mr. Jackpot is a patient in lunatic asylum, but occasionally he's of sound mind. And during that time, he entered into a contract with Mr. Bill as per Indian Contract Act 1872, identify the nature of contract. You saw here, Mr. Jackpot is a patient of lunatic asylum, means he is having some problem. Right? But occasionally, he is of sound mind. And during that time, which time? Sound mind. He entered into a contract with Mr. Bill. Okay, during that time when he was of sound mind, he entered into a contract with Mr. Bill, identify the nature of contract. What about that contract? What do you think? Obviously the contract is absolutely valid. Because, the person who is of sound mind sometimes and sometimes of unsound mind. At the time of contract, he was of sound mind, therefore contract will be absolutely valid. Next, M, a person of 16 years of age, enters into a contract with N without disclosing his age. Okay, M has not disclosed his age. He's a minor, right? And without disclosing his age, M enters into a contract with N, thereby inducing N to enter into a contract. The contract is dash. Can I say M has done something wrong? Yes, M, a minor, has done something wrong. He has not disclosed his age and he has entered into a contract. So what about the validity of such contract? It will be valid or not valid? What do you think? So obviously contract shall be void. I hope you know minor can always plead minority, even if he does fraud or anything. Okay. Next, contract for the benefit of minor is valid. Minor can be a beneficiary. Contract in which minor is a beneficiary is a valid contract. So answer is option A. Okay. Then, an agreement for rendering services entered into by a father on behalf of minor daughter. Come on, father has done the contract on behalf of minor daughter. Can parents enter into a contract on behalf of minor? Yes. Such contracts are absolutely valid. Valid contract. Parents of minor can enter into a contract on behalf of minor. Such contracts are absolutely valid. But parents of minor cannot do contracts for purchase of immovable property. Otherwise they can. Next, Mr. A promises Mr. B without any intention of performing it. You saw A has made a promise to B without having any intention to perform it. This is a case of dash. What it is? Cheating, fraud, valid case, none of the above. What it is? Come on, tell me. It is obviously fraud. He's making a promise but he's not having any intention to fulfill it. Then why is he making the promise? Right? Then where a person asserts something which is not true. Person is telling something which is not true as true. He is asserting something as true but it is not true. Because he believes it to be true. Because he believes it to be true. This assertion amounts to dash. It is a case of misrepresentation. Because you saw there, he is not having intention to mislead the other party. He is not having intention to cheat the other party. He has done that innocently. Okay. Come on, next. Consider the following. Come on. Active concealment of fact. Active concealment of fact. Promise made without any intention to fulfill it. Breach of duty which gains an advantage to the person committing it. Yes, including mistake as to subject matter. Which of the following amounts to fraud? Come on, which of the following is fraud? So obviously answer is 1 and 2. 1 and 2. Do you remember in fraud you can see these two statements? Active concealment of fact, and second is promise made without any intention to fulfill it. That means he is doing it intentionally. Right, so answer is option A. Next, X owes 15,000 to Y. X pays 12,000 to Y in full and final settlement of the outstanding due. This is a case of dash. Come on, it is a case of dash. He was liable to pay 15,000 but he paid 12,000 in full and final settlement. It is a case of dash. It is a case of remission. Right? Then when parties agree to cancel the contract, it is called as dash. Come on, parties agree to cancel the contract. Cancel means rescission. That is to resign. Yes? Then when the contract is discharged, come on, when is the contract said to be discharged? The topic, if you remember, discharge of contract. Yes, by mutual agreement, actual performance, impossibility of performance. So answer is all of the above. If you remember the point, it is all of the above. Okay? Yes. Then supervening impossibility is discharge of contract by dash. Come on, answer me this 24th. Supervening impossibility is discharge of contract by dash. Unknown impossibility, loss of evidence of contract, material alteration in the facts of contract, impossibility arising after formation of contract. So very simple, it is just like we are doing meaning of supervening impossibility. So answer is option D. Okay? Because you know, here impossibility arises after formation of contract. Come on, next. If no time is specified for the performance of contract, it must be performed within a reasonable time. Correct? Now what is the meaning of reasonable time? Reasonable time means how much time? So reasonable time which seems reasonable for the promisor, which seems reasonable to the promisee, which is determined as reasonable by third person, which is reasonable under the facts and circumstances of the case. So do you remember I told you reasonable time is not the matter of law, it is the matter of fact. It differs from case to case. It differs from circumstances to circumstances. Therefore, answer is D. Okay. Yes, next. Each party to contract is bound to perform as part of obligation. After parties have made a due performance, contract comes to an end. In such case, contract is said to be discharged by dash. Come on, when party has performed their obligation, contract is said to be discharged due to what? Due to performance of contract. Very simple. Okay, come on. 27th one, everyone, 27th one, read carefully. You have to read the statements and choose the correct answer, okay? First, in breach of contract, party that has suffered loss cannot sue for the breach immediately after the repudiation. Repudiation means after the cancellation, and he has to wait for the actual date when performance is due and then sue for breach. First you tell me this statement is true or false. First statement is true or false. Just tell me this much. First statement is false. As I told you, the party can sue immediately also, and party can wait for the day of performance also. It depends on the party. Okay? Yes. And second statement, the breach of contract may be actual or anticipatory. Actual breach may take place either at the time of performance, okay, or while performing it. Okay, so yes, second one is true. So first one is false, second is true. So false and true, false and true, false and true, false and true means option D is the right answer. You saw this question was asked in January 2023 CSEET exam. Okay. Yes, in case of breach of contract, which of the following remedy means relief, is available to aggrieved party? Which remedy is available for suffering party in case of breach of contract? What can party do? Party can sue for damages, party can sue for rescission, that is cancellation of contract, party can demand actual performance, that is specific performance. Friends, answer is all of the above. However, this few terms like specific performance, this was not there in your syllabus, but it is one of the remedy, right? You know what is this? Sued for performance? Damages you all know. Sue for damages everybody knows. Sued for rescission, what is that? Sued for rescission? Rescission means to cancel. So if first party is not performing the contract, if first party has refused to perform, can you cancel the contract? Yes. So that is also a relief for you. So you know A, you know B. What is C? Specific performance. You know, in many cases, whenever there is a breach of contract, you sue for damage, you sue for damage, you sue for damage, right? But you know, sometimes money is not the remedy. Sometimes money will not give you relief. You want performance only. So if the court feels that in this contract money is not the remedy, so court in that case can pass order of specific performance. In that case, court can pass the order of specific performance. Understood? So it is also the remedy. So answer is all of the above. Yes. Next is breach of contract on the due date is known as dash. On the due date is known as dash. What is the answer? 29. 29 is obviously actual breach. Okay. The next, A agrees to employ B on 1st April, but on 24th March he writes a letter to B informing him that he did not join the service. This is known as dash. Actual breach, rescission, substitution, anticipatory breach. What is this called? It is called as anticipatory breach. Okay. Next, exemplary damage. Exemplary damages are otherwise called as dash. Now you will say you will say that, sir, we have not heard about this. Yes, that's why we are discussing it here, because they are asking anything in exam. So you know, exemplary, there are different types of damages. In unit 5 we did meaning of damage, and then we did different kinds of damage, right? So different types of damages you don't have in your syllabus, therefore we did just the meaning. In different types of damages there is something called as exemplary damage. What is the meaning of exemplary damage? Exemplary damage means damage to the reputation. Okay? Damage to the reputation is called as exemplary damage. And exemplary damage is also called as punitive damage, vindictive damage. All these are the different names of damage to reputation. Okay? Understood? Yes, damage to the reputation. So yes, what is the answer now? Exemplary damage are also called as As I told you, these are different names: punitive damage. So answer is both A and B, because these are the different names of exemplary damage. Okay. Yes. Next is, when a person is restrained by court from doing what he promised not to do, it is called as dash. When a person is restrained means restricted by court from doing something what he has promised not to do. So if you promise I will not do this but still you do that, so court will pass the order, don't do that. So the order of court for not to do something is called as dash. It is called as injunction. Again, injunction is a very basic term which is used for understanding not to do something. Okay. Yes. So that is, quantum merit, first one, A option. Quantum merit, I told you, whenever we give some advance, you can restore that advance. That is application for quantum merit. Rescission means to cancel. Specific performance, I told you in the previous MCQs, that you can demand performance when money is not the remedy. Okay, so answer is D, injunction. Next is novation takes place by dash. Novation, substitution of contract. You are entering into a new contract, replacing the current contract. That is called novation. But whenever we enter into a new contract, replacing the current contract, for this, all the parties have to agree for that. Only then it is possible. Otherwise, it is not possible. So novation is possible with the consent of the parties. That is A. Mutual consent of both the parties. Remember this thing. Okay. Yes. And last MCQs, last two. In which of the following situations original contract need not to be performed? In which circumstances contracts are not required to be performed? Which circumstances? Okay. First, when parties substitute a new contract for the old one. What do you think? When parties make a new contract, can I say old contract need not to be performed? Correct. Then when parties to contract agree to resign the contract, resign means cancel the contract. So if party agree to cancel the contract, now do they have to perform anything? No. Third, when parties to contract agree to alter it. When parties to contract decide to alter the contract means make changes in the contract. So do they have to perform the old one? No. So the question was, in which of the following cases original one need not to be performed? So answer is all of the above in all the three cases. Okay. Next, an agreement which restricts a person's freedom to marry any person of his choice is against the public policy and is dash. What is the answer? Obviously, answer is void. You can't stop anyone from getting married. Do you remember agreement in restraint of marriage? One of the agreements which are declared as void. Right? So you can't stop anyone from getting married. Such agreements are absolutely declared as void. Yes. Any doubt in this? Yes, so we are done with MCQs also. I hope everyone is clear with this. The entire chapter of Indian Contract Act 1872 along with MCQs. Yes, if you have understood everything. Yes, I will share this MCQ file, don't worry. You can see so many more MCQs in the previous series also. Okay, so please watch our previous series also. Okay, yes. And the next thing is, if you have understood everything, beta, all the best. Please study nicely. Be ready for your exam. Don't skip anything. Be confident and score absolutely fabulous marks. You all have to score highest marks across India. Try for it. It is very easy. Only 4 papers, MCQ, no negative marking. If your concepts are clear, you will rock it. Trust me. Okay. So if you have understood everything, just write thank you in the comments after watching the entire video. Thank you so much everybody. All the very best. God bless you all. Take care. Thank you so much.